morning, everybody. Welcome to the Courtroom Files live on a Monday, the 27th of October, 2025. My name is Michael Groff, filling in for fearless leader Dan Soul, who is on vacation for the next couple of weeks, which means you are stuck like Chuck with me during that time. But we're going to have a lot of fun. It's Halloween week after all, so you know we've got some surprises, I'm sure. It's always a fun time. Let's start our day in a different place than normal. We'll begin with first appearances with Judge Wade Mercer in Florida.
Good morning, everyone. We're here for first appearance today. I've got 8:29. Today is October 27th. Corporal Drown, good morning, sir. Have you had a chance to play our first appearance video?
Good morning. Yes, we have, Your Honor.
Great. Ladies and gentlemen, at the jail, I'm Wade Mercer. I'm the county judge in Jackson County doing first appearances this morning. We have our two attorneys, both of which are in the courtroom today. I want to ask that they introduce themselves. Make sure you can see and hear both of them.
Jake Mitchell on behalf of the state.
John McDaniel, Public Defender's Office.
Audio and video working good, Corporal?
Yes, Your Honor.
Perfect. We do not have friends or family here on any of the first appearance cases. So the first case will be Christopher Landry.
I knew that was coming.
Stephanie emailed you about her, contact you about him.
Nothing at all since he got kicked out of the last program. Mr. Landry, good morning. Mr. Landry, you're here for first appearance on the charge of violation of conditional release. This is for the Teen Challenge program that we tried that apparently didn't work or allegedly didn't work. Mr. Landry, you've got no bond. I'm going to try to, actually, I don't know that I think I would let him still have the same bond, Mr. Mitchell, but I'm not going to consider a conditional release again. We tried it twice. Mr. Mitchell, any objection? I mean, he arguably violated, but it was a mental health allegation. So what's the state's position on him having the same bond that was set previously?
No objection to that. We did give him the November 4th court date, right?
I'm checking that now. Mr. McDaniel, you agree you should be entitled to a bond?
Yes, Your Honor. Just whatever it was.
So Corporal, do you have that bond amount or you need me to check the file?
It's 5,000, Your Honor.
Okay, so you've got the bond. You had the right to post the bond with the same conditions that were previously set. You have court. It's not docketed. So I don't know if we did not give him a court date because of him being in that program or not.
That's right.
It seems like with Mr. Gill, it may have agreed not to give him a court date because he didn't want him to come back. But now that he's here, we need to give him a notice for his arraignment date, which would be November 4th.
Yes, we're
Your Honor.
Today's the cutoff. Just a second, Mr. Landry. Is
Yes,
today
sir.
the cutoff? Yeah, today's the cutoff. So today's the first appearance today is when it's over. So your court date's going to be November 4th. Corporal, I don't think he's been getting the notice for November 4th at 8:30. Mr. Landry, if you're in custody, they'll get you over there. If you're out of custody, it's your responsibility to be there on November 4th at 8:30. Mr. Landry, do you have any questions?
No, sir.
All right, sir. Wish you the best.
Chris, you got a $5,000 bond. If you end up, your family wants to bond you out, it's $5,000, okay?
Yes, sir.
Next case on first appearance docket is Timothy House. Mr. House, good morning. Mr. House, you're here for a hold out of Walden County. Mr. House, I pulled it up this morning trying to see if there was a bond on that warrant because the document sent from the Walton County Sheriff's Department did not mention a bond. When I pulled up the case, I think the case number is wrong, Corporal. On the teletype or the email from Walden County, they have 22553. I think it's 24553. Mr. House, I'm going to ask the jail to verify after first appearance if there is a bond on that warrant or not. I can't see the warrant. It's not in CCIS. It's not in our statewide system. So I'm not sure if it has a bond on it or not. I'm going to ask the jail to verify that. They're going to tell you if it has a bond. If it has a bond, you have the right to post it. If there's no bond, then what's going to happen is you're going to be held until you can get over to Walton County and get before one of the local judges there, which likely happen one day this week. Mr. House, any questions?
No, sir.
All right, sir. Wish you the best. Conniff Dawn Harris. Ms. Harris, good morning. Ms. Harris, you're here for first appearance accused of one count of battery. Ms. Harris, there is probable cause in the complaint. Ms. Harris, your pretrial release sheet from the jail says you're on probation, but when I looked at the DOC website, it looks to me like it's a conditional release, what they used to call parole. Is that what you're on, ma'am?
Until December the 18th or 19th.
So what I'm gonna do is this, there is probable cause in the complaint. I'm gonna set your bond at $5,000 cash or surety. Don't try to post the bond because I want to ask Mr. Mitchell to notify the authorities, the appropriate authorities, someone with DOC of your arrest. We'll see if they place a hold on you or not. I don't know if they will. It's a 7-day hold. If they don't, then you'll be free to post the bond I've set for you and be released. If they do place a hold on you, which they probably will, Ms. Harris, that's up to them. The most they can do is make you finish your time that you got the benefit of gain time in. That's how conditional release works. So, Ms. Harris, you do have a condition on the bond of no contact with alleged victim. So if at any point after today, you can have no contact with that person. Ms. Harris, do you have any questions?
Yes, sir.
Okay.
Well, if I'm released and my trailer's at my cousin Peggy Banks, my camper, and I am in a situation and I was supposed to get an injunction today and they didn't give me a chance before they started railroading me again yesterday, I'll be able to go back to my camper, right? Where I have
You can go back to you can go to anywhere other than the property where the alleged victim lives or,
That's where it's at.
yeah, so if she lives on that property, then no, you can't go back there.
Well,
I don't know where the
that's my
alleged victim
camper.
lives. I don't
That's
care
my
about the camper.
camper,
You
and
can't
she
go to
was
the
moving it.
property. You can have the camper lawfully moved. That's fine. But you can't go
Okay.
back to that property if she lives on that property. And I don't know where she lives,
Okay.
but you can't have no contact with her or her residence. Okay?
Okay,
We'll see you in 7 days and we'll see if Department of Corrections has a warrant or not, okay?
yes, sir, thank you.
Thank you, ma'am. After Ms. Harris, we have Liberty Wright. Ms. Wright, good
Yes,
morning.
sir.
Ms. Wright, you're coming back this morning to see if we can make any progress in your misdemeanor criminal traffic charges from the weekend. I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel, your attorney, ma'am.
Your Honor, I
Yes,
spoke
sir.
with Ms. Wright. She's going to plead of no contest to the charges as listed. The understanding should be sentenced to 6 months in the county jail, $1,078 in fines, 3 days jail credit, should be adjudicated guilty. The 2 second-degree misdemeanors will be 60 days in the county jail.
Now, Mr. Mitchell, one of these, there was no probable cause on. Is the state going to,
Yes, we can dismiss
Dismiss
the
that?
operating motor vehicle without a valid license since there was no probable cause found on that and clear to the other 2 misdemeanors.
either of those a second degree misdemeanor? Those are both first. Well, the DUI with property damage or not?
Technically,
Yes.
DUI is listed as a second degree misdemeanor,
Was
but
it with property damage? That makes it the first.
yes, I think it was a crash.
I think it was property damage. Okay, so is that agreeable with the state?
That is agreeable with the state.
So Ms. Wright, if you enter this plea, the driving with license, the no valid driver's license will be dismissed. You'll be pleading to the other 2. You also need to understand, Ms. Wright, that the grand theft is still out there. The state will
Yes,
review
sir.
that and decide whatever they're going to decide on that. But you're resolving everything but that if you enter this plea. Ms. Wright, any questions about that?
No, sir, not about that. I was just wondering if my sister or Mr. McDaniel had gotten a hold of you about my mother's death to make sure that you know I'm not lying about it.
No one have heard nothing, and no one is here. Is anyone here on behalf of Ms. Wright? No one is here this morning, Ms. Wright. So no one is here, ma'am, on your behalf to give us additional information.
Okay,
Ms. Wright, is this the plea you want to enter?
yes, sir, I'll take it.
Ms. Wright, I will tell you that if there's some documentation, ma'am, that your mother did in fact pass away recently, then you going to the funeral might be an option, ma'am. That requires cooperation and input from the sheriff's department because they have to
I
go in
understand.
with you and supervise you, basically be with you. That can happen if the funeral hasn't taken place yet. You weren't sure about that, the date of her passing. But Ms.
Yes, sir,
Wright,
thank you.
yes, ma'am, I'm going to accept your plea of no contest to the charge of driving under the influence and refusal to submit to breathalyzer exam. Ma'am, I'm going to adjudicate you guilty of those 2 offenses and sentence you to 6 months in the Jackson County Jail on each case concurrent, running at the same time. Credit for 3 days you've already served. I'm going to impose the standard court costs and fines of $1,078 on the DUI, waive the court costs and fines on the refusal, and the no valid driver's license, as Mr. Mitchell has already said, will be dismissed as part of the agreement. Ms. Wright, this is a straight time sentence. And what I mean by that is there's no probation involved. You certainly may or may not get gain time. That's between you and the jail. And Corporal, did we already give her a court date on the felony charge this weekend?
Yes, sir,
Yes.
Oh, we
Your
did.
Honor.
Never mind.
Ms. Wright,
thank you.
this sentence will be serving or not completed, but it'll be in the process by the time you get to felony court. Ms. Wright, do you have any
Yes.
questions, ma'am?
No, sir, I think you covered it all.
All right, man. Wish you the best.
Thank you.
Good morning again, everybody. Welcome to the Courtroom Files Live. It's a Monday. We've seen that defendant before. That was the story. Was very curious about. There were some questions as to the death of her mother, whether she was lying about that story, and now it looks like she's going to spend a few months in lockup. Anyway, we are in Wade Mercer's first appearance court this morning, and thank you again, Bailey, for the $20 super chat there. Really do appreciate that.
Daniel, your attorney.
Your Honor,
Back to Wade Mercer.
Ducker, he's entered no contest. The charge is listed. You understanding he'll be sentenced to 30 days in the county jail. He'll have 3 days jail credit, be a $370 fine. He'll be adjudicated guilty and he has waived his right to a jury trial and call witnesses.
Mr. Mitchell's agreeable with the state.
It is, Your Honor.
Mr. Ducker, did you hear that agreement, sir?
Yeah, speak up for him.
Yes.
Mr. Ducker, do you have any questions about that agreement? Any questions
no,
about
sir.
the agreement?
No, sir.
Mr. Ducker, is that the plea that you would like to enter?
Yes.
Mr. Ducker, I'm going to accept your plea of no contest to one count of trespass, sir. I'm going to judge you guilty of that offense, sentence you to 30 days in the Jackson County Jail. You've got credit for 3 days you've already served. I'm going to impose court costs and fines in the amount of $370. Mr. Ducker, there's no probation involved in this sentence. It's just a straight time sentence, and you certainly may or may not get gain time from the jail. I can't promise you that. I'm just telling you it may be possible that you get some extra gain time off of your sentence. Mr. Ducker, I wish you the best. Do you have any questions?
No, sir.
Have a good day, sir.
Thank you.
Court costs and fines and liberty right.
See right there, we jump from there in a second. But
Timothy Cook. Good morning, Mr. Cook. You were brought back today to give us time to see if your mother came and she wanted to be heard from. She's the alleged victim, sir. And actually, yeah, she's the alleged victim in one of these charges and the owner of the pet in the other case. She is not here today, Mr. Cook. Your mother's not here. So you remain on the same schedule I told you about this weekend, the felony case, the date I gave you. You've got the bond I set for you this weekend. The no contact condition still applies. If she wants contact, we'll cross that bridge. But right now, the no contact still applies. Mr. Cook, do you have any questions?
Yes, sir.
Okay.
What's it called when you leave a dog in a cage for 2 weeks with no food or water?
Mr. Cook, I said, we're not going to talk about that case today. Okay, I mean, there's
We're
a
here
bond
on
set.
the
We
mission.
can post a bond.
Okay,
Mr. Cook, wish you the best, sir.
thank you, sir.
Yes, sir. Corporal, I believe that takes care of the first appearance list unless I missed somebody. Anything else from the jail this morning?
no, Your Honor, that was everyone.
Thank you. Mr. Mitchell, anything else from the state?
Nothing from the state, Your Honor.
And Mr. McDaniel, anything else from the public defender's office?
No, Your Honor.
Dawn, Stacy, anything else? All right, ladies and gentlemen, that concludes our first appearance list for this morning.
All right. Well, that was a very fast first appearance from Judge Wade Mercer. So with that in mind, I guess we can switch gears a little bit. We'll see what's going on up in Michigan. The Honorable Judge Michael K. McNally, of course, we refer to him as Judge Dad. Let's see what he's got going on.
Diane Marie Sturgill, 25W36193. Thank you.
You're welcome.
Take it easy.
Morning, Your Honor. It's Yellow Gary. Along with co-counsel, we got it told.
Ma'am, your name? All right, so I have a charge here, possession of controlled substances. She's positive for a cocaine metabolite allegedly with regard to a test of October 2. What is she going to do here?
You need her plead guilty. May I present to you a confidential analysis that she's seeing her underlying issues? She reached the finish line and then ran back. She was near the end of getting off of this charge, and there are underlying issues where she sought the support. It has nothing to do with an addiction.
I understand. Call Jessica.
May I present this to you?
You can. Ma'am, do you understand what your lawyer has said?
Yes.
You are here on a first technical violation. If you plead guilty or if you're found guilty here, you could be incarcerated for a period of 5 days. Do you understand that? And did you sign, read, and understand an advice of rights form?
Yes.
If you plead guilty, you will be giving up all those rights and there will be no hearing. Do you understand that? Did you file an appearance post judgment?
I think I did last week.
Okay, good enough. All right, so this is how you wish to proceed, correct, ma'am? You understand if you plead guilty, you're giving up all those rights?
Yes.
All right, to the charge that you failed to refrain from consuming alcohol or drugs, testing positive for a cocaine metabolite on a test of October 2 of 25. How do you plead? Did you in fact consume cocaine, say, within the 10 days before that?
How many days? How many days did we take?
3.
Okay, but it was within 10 days of October 2, right? And you consumed cocaine knowingly, correct? Anybody force you to plead guilty?
No.
All right, I'm gonna accept your plea, find it to be an accurate plea, made voluntarily and understandingly. Mr. Zolnick, give me 1 second, let me look at this. Your name? Tell me what her issue was. What prompted this? This is bad. You gotta get away from cocaine. That's bad stuff, right? What was it, Mr. Zolnick? Under what circumstances?
She was convinced to use cocaine by until she went out with it that evening. It relates to a previous issue she had that she didn't raise her probation when she was 16% seeing, and it's something she'd rather not reveal and open to court to her, that has traumatized her, and this fellow talked her into it, and she got caught. She's owned up to it.
She was ready to,
I sent her to a new therapist, Your Honor, to address what I think are ancillary issues, not just the use of cocaine or narcotics.
did I? So she was sentenced on April the 2nd of 25. Right?
That's what I have, yeah, April 2nd of 2025.
How often is she testing?
Right now, she's testing on twice monthly.
And when is she scheduled to have her testing decreased further?
Testing is supposed to be decreased to once monthly beginning next month, November 10th.
Ma'am, is there anything you would like to say?
I just want to apologize for disappointing, you and also my family. And I'm also disappointed myself because I was doing really good and I shouldn't have let it, the pressure, I guess, get to me. And I just hope that you can consider that too, please. Thank you.
All right. Can I hand you this document? It's from Counseling Therapy Associates. I just want you to take a look at that, and if you tell me if you have anything else that you'd like to say after you take your time.
No, this is good. I mean, if she's compliant, otherwise, Judge,
I understand.
she was very honest about her youth, was very honest about the mistake. I've had no issues with her previously. Everything else is completed. She did have days on the SoberLink device she completed. She was at weekly testing prior, appeared to every test, never missed a test. It was negative for all of them except this most recent one. She was in outpatient services substance abuse. She technically did complete that. I'm glad to see that she's now re-enrolled. I think that's a good idea for her to get re-enrolled in substance abuse treatment. Victim impact panels completed and all 48 hours of community service are done.
Good. Anything else over here that you want to say?
Just want to let you know that there's a corollary counseling that you seek along with substance use.
Good. Pay additional, I'm gonna keep you on probation. Pay additional costs of $100. Serve 1 day on the court work program and pay $35 for that. Test weekly for 2 months. And if you're clean, I'll make it bi-weekly then for 4 months, and then I'll revert it to monthly. Defendant to attend treatment. Can you just give me the initials of that place?
CTA.
CTA. Okay? I wish you well.
Thank
Can you pay that today?
Yes.
Don't do this again, okay?
trustee meeting. You guys see me till on.
Well, I hope you still, at some point, we're not. Thank you.
Thanks a lot. Have a good day. Thank you. Cook Thomason, Jason Michael Cook Thomason, 24B146297A. When I get to civil infractions, I'm gonna ask some of you to come up and have a seat at the table. Okay, just so we can move along a little bit. Your name? You're charged with, you're on probation and you're charged with failure to attend a decision-based driving program, level 2 with Class A training, and failure to pay fines and costs of $888. Those are the charges. If you have one technical violation previously, if you plead guilty or if you are found guilty of either one of these or both of these, you could be incarcerated as follows. If you have 2 violations as a result of this show cause plus the one prior, you could get 15 days. If you're not convicted of any one of these, I'm going to dismiss it. If you're convicted of one of these, then you could get 10 days. So you get 5 days. You could get 5 days for each technical violation. Do you understand that?
Yes, sir.
Did you sign the advice of rights and read and understand the rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
You have the right to an attorney. Be happy to provide you with one at public expense. Would you like an attorney?
No, sir.
All right. As the count 1 that you failed to register, attend and complete the decision-based driving program level 2, how do you plead?
Guilty, sir.
Calling number 1. Did you fail to register for, attend and complete the decision-based driving program?
Yes, sir.
Was the count 2?
I'm sorry, sir, what?
As the count 2 that you failed to pay your fines and costs is ordered, the balance owing at the show cause time being $888, how do you plead? Just give me 1 second. Did you fail to pay your fines and costs?
I'm scheduled, sir, yes.
Anybody forced you to plead guilty?
No, sir. You don't want.
Why didn't you attend that program?
So,
You've been on probation for what? How long?
so you.
13 months, right?
No, I haven't been on the whole 15 months.
I think I put you on probation in September of 24. Well, that's 13 months. Your name? Why didn't you attend? Why didn't you do that? This was kind of a serious charge here.
So you can schedule the appointment, you have to pay for it. That's my issue right now.
Where do you work?
So I'm a contractor and just recently so my fiance, we have 2 incomes in our house and for the last 6 months, it's just been me. And we're behind on all of our bills. Every single one.
Was she working until 6 months ago?
Yes.
That took you to 7 months into probation. Why didn't you register for the program in the beginning?
Sorry, now they're still struggling.
How much do you make?
$20.
Why didn't you come and talk to me? Did I tell you, or were you the one that I forgot last year to tell that you come talk to me if you don't have the money to pay? Didn't I tell you that?
Yes.
Of course I did. Why didn't you come and talk to me?
That is my mistake. No, I apologize.
What do you have to say? Anything?
I'm aware of the financial situation. I've done my best to work with him. We just where it is. But It is true, you have to pay the registry.
I'm not discharging you from probation until you do this. I don't know why you wouldn't come and talk to me like I offer. Why didn't you come and talk to me? I don't get that. I don't understand that. Nobody's gonna allow me to give me any reason that will cause me to understand that. Not when the judge tells you, you don't have the money, no problem, call the court, we'll go on Zoom, I'll give you an extension. Right? Thank you. I mean, you got out of this relatively unscathed. How long of a program? How many sessions is that again? Remind me.
I believe they do it in a weekend. It's 8 hours, so yeah, they must do like a Saturday, Sunday.
You to pay additional costs. Did I let you finish? Anything else? Pay additional costs of 75. Pay additional probation fees of 60. I'm extending your probation by 3 months until March 11, 26. You're to serve a day on the court work program, and you're to pay $35 for that. You're to complete the program no later than December the 31 of 25. Okay? I'll let probation set up the rest of the terms of the payment. Did you graduate?
Yes.
Maybe you need to find another job. I don't know what to tell you. Probation to set up terms of payment. You got a minute to sit with him? Good enough. That's what we're gonna do. And now you can incorporate those into the payments. All right, thank you. People against, do I have some?
All right, everybody, welcome to the Courtroom Files live again on a Monday. Yes, it's a Monday, I know, but it's going to be a fun day Monday. It's Michael Groff. I am filling in for Dan Soul for the next couple of weeks. If you're just checking us out, you're just tuning in, thank you so much for being with us. Hang out in the chat. It's a great community. We always have a spirited discussion. It's always fun. So please feel free to hang out and participate, of course. Courtroomfiles.com for all your Courtroom Files merch, should you choose to go there. All right, let's see what else is going on. You know, courts have been pretty quiet this morning, but as is so often the case on a Monday, they do pick up fairly quickly. We're going to go into another place we don't often go here. Let's see. Let's see what's going on with Judge Shackelford. We don't usually check in with her very often, but let's see what she's up to this morning. Assuming that she has her audio on.
Report.
There we go.
Yes, Judge. Mr. Asher.
That wasn't me.
We're ready to go. Yes.
All right, just one sec. We have a complainant present. Okay.
Brother, yes.
All right.
Sir.
And sir, is that Eric as?
Yes, ma'am.
All right.
Good morning, Your Honor.
Good morning. Okay, this is 25266F. Why the people versus Michael as? Can I get your appearance, counsel?
Certainly, Judge. Good morning to you and your staff. Michael Woodyard, my P number is 64612, Neighborhood Defender Service of Detroit. Judge, I'm appearing for the sentencing on the Zoom call. Mr. Esch is in person. I believe that he will tell you that he agrees to my appearance on the Zoom.
I agree.
All right, so it's a time and date set for sentencing. With respect to the pre-sentence investigative report, have you had a chance to review that with your client, counsel?
Judge, I have. There's a few things that I want to bring to the court's attention, all having to do with the proposed judgment of sentence, terms of the sentence. As it relates to the body of the report, the background information, et cetera, we don't have any changes.
Okay, and we have the complaining witness or the victim in this case, Eric S. Mr. S, under the Crime Victims' Rights Act, you have a right to make a statement before the court and imposes sentencing. Is there something would you like to make a statement?
No, ma'am, I've already talked to the prosecutors.
Oh, okay. So you've made your, because I just want to make sure you know you have that right. And if you want to, I'm all ears.
Yeah, she's telling me I get whatever been approved is approved.
I'm sorry, what's that?
So when I talked to the prosecutor, she said that whatever was agreed upon is agreed upon. So even if I say anything, it's not gonna matter.
Well, that's not entirely true.
Well, one thing that judges.
Sir, can you do me a favor though?
Yeah.
Because my court reporter has to pick you up. Can you come up?
Come on over here, young man.
And if he can have a spot just so she can get, and sir, I'm gonna ask you to start by telling me your first and last name.
First name Eric, E-R-I-C, last name S-E-S-Z.
All right, thank you. All right, sir, go ahead.
No, I just wanted to make sure that, you know, they were aware that he actually choked me, because when he was in court before, I didn't know what was, I don't know if he said he hit me, but he actually choked me.
Well, when they originally charged it, they charged it as a felony and that was one of the counts. But then in the plea offer that the prosecutor made, or the plea deal that the prosecutor made, that count was dismissed. So when I take just so you know, when I take a plea, I only have to hear a factual basis for whatever charge he's pleading to. And so that doesn't mean it's not contained in the reports. It's just that there was a plea reduction. So I just needed to know that he put his hands on you in a way you didn't want, and that there had been a familial relationship. So those are the elements of what I needed to hear to find him guilty of that count.
Okay, that'll be fine then.
Anything else?
Okay.
All right. Okay, thank you, sir. All right, Mr. Woodard, anything you and your client want to say?
Judge, if I could, in terms of the proposed sentence, there's a few points. One has to do with the fines and costs that are proposed. Mr. Ash is on a fixed income of $978 a month. After his bills and fixed outlay, he has about $150 to his name every month. So to the extent you're able to reduce costs and fines and discretionary assessments, we would ask you to do that. That's the one thing. Judge, the second thing is the report requires or suggests that Mr. Ash undergo sort of random urine drops to test for the presence of alcohol and drugs. Mr. Ash is, one thing, he's sober. He's been sober for a number of years now. The other thing, Judge, is that Mr. Ash, and he has a letter that he can provide the court. He's a caregiver for his father who is homebound and requires 24/7 care. And so if Mr. Ash is compelled to leave the premises on a random, unable to be determined timeframe, that's going to present possible challenges for the care of his father. So I don't know how you would address that. We'd ask you to just strike it, but if there's some balance we can arrive at, knowing what I've just told you, I certainly would be agreeable. And then there's one other thing, Judge, in terms of the community service, the same kind of issue. I don't know whether there's a program where Mr. Ash could take online community service or online classes. We'd like that to be put into place if it's possible.
Okay, well, I don't have that. But I'll tell you, the testing is on demand. So it's not, there's no allegations that drugs or alcohol were related in this offense, but Mr. Woodyard, I frequently just order testing on demand, which means he wouldn't have a random color. And the reason I do that is because people show up drunk to probation, and if it's not in the order, they can't be tested. So he'll be subject to testing on demand. I mean, he got a good plea deal on this case, given the nature of the allegations. And I'm inclined to adopt the probation department's recommendation. I'll waive the fine and the cost. But he has to pay the state cost of 50, crime victims' rights fee is 75. And 450 for his probation oversight, and also just waive the community service fee.
Thank you, Judge.
I mean, some of these are mandated by the state, so I can't do more.
Understood, and
So,
I explained that to Mr. Esch.
yeah, so it would be $575 total. And I will say this, if he's on a limited income, I mean, there's statutory, there's law that says he's entitled to a hearing for inability to pay. And there's paperwork in the probation department. And if you tell the probation department of your circumstances, they'll have you fill out the paperwork, and then we can make a determination either in open court or just depending on the circumstances, it might be something we're able to make without even making a record of it. So he'll have to fill out the appropriate paperwork for any additional waivers. And I have people that pay $5 or $10 a month. If you're making consistent payments within what you can afford, that's also something I would consider. You do have a period of probation for 12 months. He will do 5 days of community service. I mean, the allegations here are not good. In the city of Taylor, as directed by probation, provide proof, or he can do court watching if he needs to for medical reasons, where he would, if people aren't able to do community service, they come in and they court watch, and he could do that as well. He could talk to the probation department about that. Abstain from the use or possession of alcohol or controlled substances unless they're prescribed by a physician. Documentation will be required, and that's for the term of probation with testing on demand at his expense. He's to continue his mental health treatment through Teen Wellness Center and follow all therapeutic recommendations and provide proof. He's to complete the 26-week batterers intervention program as directed by probation through Better Choices, provide proof and follow therapeutic recommendations. He's to complete the anger management program as directed by probation through ETRS and provide proof, follow all therapeutic recommendations, attend and complete any other ancillary services deemed warranted. He cannot have any assaultive, intimidating, or threatening contact with Eric S. Mr. S, Eric S, do you two live together?
No, ma'am, we live together, but on, when he got arrested that Wednesday, I packed up and moved out by Friday.
Okay.
Because there was no way we were gonna live together. I didn't trust him for what he did.
No, I understand that for certain. I guess my question is, the report says no assaultive, threatening, or intimidating behavior. So it's not that he can't see you. And I'm assuming that has something to do with the fact that your father resides at this house.
Yeah.
So you still want to be able to come over and visit.
Yeah.
And he's going to be able to, don't shake your head at me.
No, I was cracking my neck.
Okay, well, don't crack your neck in no fashion when I'm saying that the victim can come see his father. Because he can. Do you understand?
Yes, ma'am.
And when he comes over, there's to be no assaultive, threatening, or intimidated behavior. He can come over, you can schedule it or let him know you're coming. So he can come over and see his dad. And you're gonna
Judge,
let him.
I believe that Mr. Michael Esch, he's certainly aware of what you've just said. And I believe, correct me if I'm wrong, Mr. Esch, Michael Esch, is that even during the pendency of this, that has actually taken place.
Have you been able to visit your father?
I visited him 2 weeks ago. But unfortunately, when I was leaving, he told the cops that I wasn't allowed to come back to visit my father unless I had something to judge.
That's incorrect. You can visit, okay? And the two of you are going to be adults, because there's an elderly man that wants to see both of his kids in the last years of his life. So make that happen. And you two, especially you, behave and make that work.
Ma'am, should I go go to the
There's
lawyer?
there's not a see, there's two kinds of no contact orders. I can say he can't come near you at all, but that would mean you can't see your dad if that's where he lives. Or there's a no assaultive contact, which means you can still see each other, but he can't hit you, harass you, intimidate you. And that's what's in place. So when you leave, you should be able to go down to the front, the clerks and ask for an ROA, and it'll show and tell them why. And they'll should be able to give you something that says no assaultive contact. You can go and visit your father.
Do I have to communicate, send him a text, or how does that work?
I mean, that's between you two. Can you have an adult text with him so he can come see your elderly sick father?
I'm not gonna deny him from seeing his dad, Your
Okay,
Honor.
what I'm asking you is, how do you want to know that he's coming?
He can text me.
Text him. Okay?
Yes, ma'am.
All right, no weapons, no ammunition, no driving without a valid license. If you weren't fingerprinted already, you need to be printed, okay?
Yes, Your Honor.
All right, we're all set. Thank you.
Judge, thank you very much. Have a wonderful day.
Thanks.
Well, a lot going on there in Judge Shackelford's court. We don't usually go there, but she's not always online and streaming and all of that, but it's good to see something a little bit different. Let's see. We've got a lot going on in the courts right now. We've got some Hollywood Square action going on down in Kansas. I guess we could check in maybe for a couple of minutes here on Judge Webster just to see what's going on. There seems to be a lot happening in Kansas. There's a lot happening. Look at this.
You too.
Good morning, Judge Webster.
Black on the record in BU 2025 TR 1228, State of Kansas versus Peyton Nicole Black. Please announce appearances.
Jerry McGee on behalf of the state.
John Stang on behalf of Miss Black on behalf of Mr. Levitt of our office.
And Miss Black, where are you?
Right here, Your Honor.
Oh, okay, thank you. And Mr. Stang, how does your client wish to proceed on this one count of driving under the influence of alcohol and drugs dating back to May 22nd of this year?
As I understand it, we may have just recently received some additional discovery, and Mr. Levitt would like some additional time to discuss that with the client. So if we could have one more continuance, it'd be greatly appreciated on the, I guess this would be the control docket.
Okay, Mr. Regier states response to the request.
No objection, Your Honor, if the court is prepared to continue the bond and find that this is a defense request for speedy trial purposes.
And it would be a defense request.
Miss Black, your bond will be continued in the amount of $1,500 as you posted it on May 23rd of this year, with the added condition that you reappear at the next court date, which will be at your request, continued to what date, Jen? For control status on Monday again?
December 29th, Your Honor.
Counsel and the defendant, can you be back December 29th at 9?
Yes, Your Honor.
Okay. Mr. Stang, can?
Yes,
Mr.
we can make that
Levitt?
work.
All right, then this matter is continued at the defendant's request to December 29th, 2025 at 9 a.m. Defendant is continued on her bond, all existing conditions, and the added condition that she and counsel reappear on December 29th will remain. Thank you. Mr. Levitt or Mr. Stang, have you anyone else on the docket?
I've got three more. One more for Mr. Levitt we'll go with. Bruce Lacey, and I saw him up there earlier.
All right, Ms. Black, you're excused from today's hearing. You may
Looks like he's
go.
wearing yellow.
Your Honor.
Yeah. Yes, Ms. Black. Was that you, Ms. Black, or was that Jim?
I just said thank you, Your Honor.
Oh, you're welcome. Thank you, Ms. Black, for your time. You're excused. All right. Now, let's see. Now let's move back down to Lacey.
That should be 25 TR 1229.
We are on the record in BU 2025 TR 1229, State versus Bruce F. Lacey. Please announce appearances.
Jerry McGee on behalf of the state.
John Stang on behalf of Mr. Lacey, on behalf of Mr. Levitt.
And how does your client wish to proceed, Mr. Stang?
If I'm reading this correctly, Mr. Levitt would like a little bit more time to talk to the client. Looks like it's heading towards a plea. I'm not sure if there's been a plea offer received yet. Maybe that's what he needs to do, is get an offer in this case. If we can continue that also over the December 29th date, to be appreciated.
Mr.
At our request,
McGee,
obviously.
any objection?
No objection from the state, Your Honor, if the court is prepared to continue the bond and find this is again a defense request for continuance for speedy trial purposes.
This is found to be a continuance at the request of the defendant for plea negotiations. Mr. Stang, I will grant that, but if you think it's going to be for plea at the next hearing, I would request that you, if at all possible, be ready to present the alcohol and drug evaluation.
Yes, we'll make a note.
All right, so continued at the defendant's request to December 29th at 9 a.m. Defendant is continued on his bond with the added condition that he and counsel reappear December 29th at 9 a.m. That's that $1,500 surety bond you posted, Mr. Lacy, back in May. And all terms still apply with plus the added that you reappear. Okay, thank you, counsel. If there's nothing further, Mr. Lacy is excused from today's proceedings and we're in recess on his case. And then Mr. Stang, you have others.
Would be the next case, 25 TR 1895. That's just a
All right.
traffic, I think, failed to yield. I'll go ahead and call it.
Okay, on the record in BU 2025 TR 1895, State of Kansas versus Kelly Hay. Please announce appearances.
Gary Regier on behalf of the state.
John Stang on behalf of Mr. Hay. We've applied for diversion. I have not heard back yet on that application. I'd ask that we continue it to the 29th date, and hopefully we'll have an answer before that date and have it resolved. We also haven't received the discovery that was requested back in September. I guess they're in the process of getting that to us.
Any objection to continuance, Mr. Regier?
No objection, Your Honor.
It would be
All
at the
right.
defendant's request.
I will continue this at the defendant's request. I will also order discovery be turned over, and if necessary, Mr. Stang, you can journalize that and I'll approve it.
And Your Honor,
Mr. Regier?
state's information is that discovery was provided approximately 1.5 months prior.
All right, well, I'll let you guys work that out. I know that sometimes these newfangled systems aren't always ideal, so.
We're following up on the email. I checked. I never got the link email, but we sent the check in beginning of September. So I would have expected it by now. We're just trying to figure out where it ended up going to. So it should get taken care of rather quickly. We've
All
already
right. Very well, and then also the diversion, if that's gonna happen, that needs to happen before that date.
understand.
As council knows, you may not have to be here if it's filed by then.
Thank you.
Thank you. Okay, Mr. Hay is excused. We're in recess on his case.
Next case would be Angela Van Cam. She's got two cases, both 24 TRs. First one 2607, the second one 3390.
Before we move along, can I get a date for that hearing on the last case, please?
That 29th, December 29th. Thank you for following up on that. We're gonna have that date full if we're not careful, aren't we? All right, we will be on the record now in case numbers BU 2024 TR 3396 and 24 TR 2607, State of Kansas versus Angela N. and Angela Nadine Van Camp in each case. Please announce appearances.
Regia on behalf of the state.
John Stang on behalf of Ms. Van Camp, and she is seated behind me.
Are you sure?
Yep, I got two people behind me.
Oh, I'm looking behind Mr. Ariano. Hello there. I was gonna say, I don't see her, but I'm talking to Mr. Stang, not Mr. Ariano. That makes a difference. All right, how does she want to proceed, Mr. Stang?
My understanding is if we plead to one case, the state's willing to dismiss the second case. We'd like to enter a plea to the 24 TR 2607. I believe that's a no proof of insurance along with a improper illegal registration.
And Mr. Regier, your position on that?
Your Honor, pursuant to plea negotiations, upon successful entry to all charges in 24 TR 2607, the state is prepared to dismiss 24 TR 3396 in its entirety.
All right, so she's going to plead in 24 TR 2607 to all charges. Did I hear that right?
Yes, and I
That
believe
is the
that.
state's understanding, Your Honor.
And that's count one insurance and count two registration violation.
Correct, Your Honor.
And
I don't
then,
have the date in front of me of that ticket. I mean, She knows,
And-
she remembers being pulled over in Butler County and those occurring. But
It
I
is,
can't,
it is alleged to have been 9/25/24. Is she pleading no contest or guilty?
she'll plead guilty.
Okay.
9/25/24.
Well, I was looking at 26, say, oh yeah, date 9/25/24. September 24th of the year 2024.
We're ready to proceed.
All right. Okay, Miss Van Camp, you've heard the attorneys talking about your two cases, have you?
Yes, ma'am.
And have they accurately stated the agreement that you've made with the state through your attorney?
You gotta speak up.
Yes, ma'am.
All right. Yes, they record what's being said, so they can't pick up just nods. All right. So how do you plead to count one? We're going to address case 2024 TR 2607. How do you plead to count one, operating a motor vehicle in Butler County, Kansas on September 25th, 2024, at a time when you did not have registration or your tag was expired? You said guilty? Okay. And on that same date, it is alleged that that vehicle that you were driving did not have liability insurance. How do you plead to no insurance?
Guilty.
Is anyone making you enter these pleas of guilty today by any threats or promises other than the plea agreement?
No, Your Honor.
Do you understand that with this plea, you'll be found guilty and unable to appeal your conviction?
Yes, ma'am.
And do you understand you're also giving up your right to a trial in this case with this plea?
Yes, ma'am.
All right. Do you remember where you were cited or where you were driving when you got these citations?
I was in El Dorado, I believe, El Dorado, Kansas.
Inside the city limits?
Yes, ma'am.
And that's what you agree, Mr. Regier?
One moment, Your Honor.
All right. Just to make sure we have jurisdiction, which I'm confident we do, but I need a record of it too. Well, now, let's see. She may be addressing the other ticket. We are talking about the ticket September 25th, 24. And it looks like she may have been in Towanda instead of.
Towanda?
Your Honor, with all due respect, although if the court will permit me.
Please do.
Your Honor, although the state does acknowledge that the ticket in this matter does appear to include an address within that particular city limits referred to by the state, the location of the ticket appears to be indicated on the ticket to be 254 at milepost 25. The state's information is that is approximately within El Dorado city limits.
Okay. All right. Very well. And you agree with that, Miss Van Camp?
Yes, ma'am.
All right. So that does give us jurisdiction. Thank you, Mr. Regier. Yes, I was reading your address instead of the citation address, Ms. Van Camp. All right. At this time, I accept the defendant's plea as freely, voluntarily, and knowingly given, and that there is a factual basis based on her recitation and the state's recitation of her jurisdiction. Accordingly, I find the defendant guilty of counts 1 and 2 in BU 2024 TR 2607. Motion of the state for plea agreement, case number 24 TR 3396 is dismissed with prejudice as part of the plea agreement. And recommendations for sentencing in the 267 case, Mr. Regier.
One moment, Your Honor.
Okay.
Your Honor, with respect to count 1 in the 2607 case, the state is recommending a $50 fine that the court impose court costs and an underlying sentence of 30 days to run concurrent with count 2. With respect to count 2, Your Honor, the state is recommending the minimum fine required by law of $300. The maximum underlying sentence outlawed by law of 6 months for a Class B misdemeanor. The state is further recommending, pursuant to plea negotiations, reporting probation of 12 months, subject to all standard conditions, including a $60 probation fee. Notwithstanding the plea deal made in this matter, which does contemplate dismissal of the other case, and reviewing the tickets in both cases, the alleged occurrence dates appear to be approximately 3 months apart from each other. Therefore, the state does respectfully submit that a 12-month reporting probation is appropriate.
That's acceptable, defense, Your Honor.
Thank you. Mr. Regier, on count one, you said you recommended a $50 fine, and what did you say about sentence, if anything?
A 30-day underlying sentence concurrent with the maximum underlying sentence allowed for Class B misdemeanor for count 2, Your Honor.
Which was a $300 fine and 6-month jail sentence, right?
That is the state's understanding, Your Honor.
Suspended, okay. All right, so Ms. Van Camp, I'm not going to address attorney fees because you've worked those out privately with Mr. Stang and his firm, so that's up to you and him to work that out. But at this, so no attorney fees because he's not retained, or he's not appointed. But on count one, driving with expired tag or without registration, your fine will be $50, a suspended 30-day sentence. Count three, your fine is $300 plus a 6-month sentence. These two sentences will run concurrently. You will not have to serve the sentence as long as you successfully complete a 12-month, you said non-reporting or reporting, Mr. McGee?
The state is recommending reporting probation under the particular circumstances of the pursuant to the plea offer, Your Honor.
Yes, okay. All right, and you won't have to serve the sentences as long as you comply with your probation, because I will grant you probation for 12 months, but you must see a probation officer. You'll have to call that probation officer after court today at 316-322-4153. Your initial report will be today by telephone, and then you'll have to do whatever they tell you to do after that. There will be a list of standard conditions that they'll go over with you, such as curfew, travel restrictions, and such. And then your, in addition to your $50 fine and your $300 fine, you'll have 108 court costs and $60 probation supervision fee, which comes to about $518. How much time do you need to pay that?
I'm not gonna pay it today. Well, there. Can we have 30 days, Your Honor? That gives them a chance to get it into the court clerk's office.
Right, we have to get the journal entry filed and so forth. Now, you could technically walk into the clerk's office and pay it today, but you'd have to have somebody legally drive you over there with a legal vehicle, and I'm gonna give you 30 days, because if you call the clerk's office, they'll tell you how and when you can, or approximately when you can file online if you want to pay that online.
Thank you, Your Honor.
So one of the conditions of your probation, violate no laws. Another is follow the standard conditions that they give you. The other one is pay the $518 in total within 13 days, but I give them discretion to give you a little more time if they want. I think that covers it. Mr. Regier, was there anything else I needed to address?
Your Honor, if the court is ordering that the 2607 case be paid in full within 30 days or as determined by the court services officer, as well as granting my office leave to dismiss the 3396 case pursuant to plea negotiations, the state has nothing further.
The court is granting all, as you said. Do we need to have her get her picture and prints taken on either of these cases or both of these cases? I don't think so. I think she made bond at least.
Yeah, I think she was already processed.
Yeah, I think she was too. I see it looks like she was on the one we just sentenced her for. Let me double check on the other one. It looks like she was, so we don't have to worry about processing. All right, call your probation officer, follow the conditions of your probation, and you won't have to serve your jail time. If you don't do all of those things, you may end up before me, and I may make you get I may revoke your probation and make you serve your jail time, which I don't think anybody wants to see you have to do. All right, we'll be in recess. Ms. Van Camp is excused on both of her cases.
All right, it's Monday morning. It's a busy Monday.
One more case.
In Kansas, in Judge Webster's court. Good morning. It's the Courtroom Files Live. My name is Michael Groff, filling in for Dan Soul over the next couple of weeks. Welcome to everybody in the chat. Thank you so much for hanging out with me this morning. Got a lot going on. The courts are starting to pick up. You might have seen our cat Freya came in here and joined me a little while ago. So if you're playing TCF bingo, which of course we highly suggest that you do that, you do have a bingo card. Well, I'm obviously not Dan, but you can just substitute me for Dan. Just say Mike instead of Dan. Instead of Ellie, who's Dan's cat, that's, well, you can use Freya, who appeared on camera, nuzzled up on the mic, climbed on me. She does that. Sometimes things minimize or you see things mess up on the screen. Well, so far this morning, it hasn't actually been my fault. So far, Freya loves to move the mouse, press buttons, and do stuff. So that's how that went. Meantime, let's see what's going on in Texas. Let's switch over there. Let's see what's happening with Judge Stevens.
So you are here with,
See what's happening here.
Mr. Producer, your attorney and the state's attorney. You're Ms. Laverne? Yes? Okay. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary? Yes. In summary, in this cause number 1029, in summary, this indictment states that on or about July 5th of this year, in Jefferson County, Texas, you committed the second-degree felony of robbery. Do you understand what you were charged with? Yes. If convicted, you face no less than 2 nor more than 20 years confinement in prison, and fines up to $10,000 can be assessed. Do you understand?
Yes.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, ordered to pay a fine of $500. Is there any restitution owed on this case? Any chance?
No, sir.
I'll check while you proceed, Judge.
Is that your understanding of the agreement? If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this charge, ma'am? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will. And because you were guilty. Show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily? Understand it, discuss it with your attorney. The contents all correct?
Yes.
State's Exhibit 1 is tendered without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and their rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All truth so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report, please. Yes. I'm going to follow this agreement and find you are mentally competent to enter your guilty plea. It's freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of the second-degree robbery. But I'm going to defer or postpone any finding of guilt so long as you follow terms and conditions of probation. The probation officer is going to go over with you all of these. And this will be for a period of 10 years, but you do well, I can shorten it to 1/3 of that, 3 1/3 years. Again, there will be fine of $500 and other terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow that. If you fail, your probation could be revoked. You could be then found guilty and sentenced up to 20 years in prison, which I don't think anyone.
I don't see where the items were recovered, Judge.
You don't see the what?
I don't see that the items were recovered. There were 7 items valued at $300 a piece, so it looks like there's $2,100 worth of restitution. Sunglasses.
Says 9 pair, totaling for $3,000.
My report reflects 7 at $300 a piece.
What do you know about that? The defense, did they ever get the sunglasses back? Do you know? They did. How did that happen? Keeping in mind, you don't want to mislead me because we'll get to the bottom of it. Don't mislead. They got them back at the law.
Stuff when they were on the wrist.
Okay. And you gave everything back?
Yes,
To the-
but they had a bag. No.
Okay. Yeah. And that, it looks like it included several pairs of sunglasses from the store, right?
That looks good.
Okay. And all of those were given back to the police,
Yes, sir.
you're saying? Man,
It was found.
Yeah, just ask Kim, you see what she's, if she's saying, I have something on it.
okay, excuse me, let me, we're in the middle of a plea hearing on this. Thank you. All right, here we go.
I don't want to.
We're not certain.
Yes, sir.
About this. The defendant says the police recovered all the items. The state does not see that in the report. I don't either. But what do can I do a tentative restitution order? Yes. And it either is paid back or the items are returned to satisfy the reimbursement. But how much is the restitution?
To me, the restitution should be $2,100, Chuck. If in the event that these sunglasses were recovered, obviously that would diminish.
Yeah, the court is going to order restitution in the amount of $2,100. But if they are all returned back unscathed, that is in the same condition they were in. So when they were taken or stolen, anyway, you will be given credit for all of that. Do you understand? But we don't know for sure because there's a difference of opinion here. But if you have a problem with it, tell the probation office if you believe whatever occurs on that restitution is not what you understand, and then we'll have a hearing. But we're going to tentatively order restitution or the return of the sunglasses in the proper, in the condition they were in when they were taken. Okay. All right. Please see the probation officer. Thank you.
It's the Courtroom Files Live. It's Monday. Did I hear that correctly? Was that $2,100 for sunglasses? My goodness. We are here in Texas. Judge Stevens will hang with him for a little while, see what's going on. Never know who's going to steal $1,900 toilet paper next. I don't know.
On Donna Arnold, 3 cases. Donna Arnold, 3 cases.
You will fight back because they'll do it to us.
Okay, so what are we doing today? This is my question. What do you want to do today? I know what you want to do. What are you asking for? I'm hearing on this. All these things. Let me see.
To reinstate. Okay, let's be a little more specific. On September 16th, she failed a drug test in the courtroom. And that was after she had 5 failed drug patches. Your Honor, revoked her bonds based upon those and ordered that there be no bond.
What are you asking for?
A bond.
Denied. I'm just standing by the record on this. This, the court, it feels futile in trying to handle this without custody. We have tried at least 2 different methods and those have failed. She's still testing positive. So we'll set it for trial.
The problem is that
we set it for trial, sir, or not?
Well, I'll talk to Mr. Hannah about trying to.
All right, set for trial. Next is Terrence Limber.
If I could speak, Your Honor, the problem setting it for trial is that she's going to be in custody probably years, 2 years for trial.
It's a tragic thing, yes, but she's had more than one occasion to deter herself from committing felony offenses, and every time we test positive, it's a felony. Come on. I mean, you want to just add those up until it's overwhelming?
She could be admitted to bond with conditions of attending inpatient rehab or something of that nature as a condition.
Court has reviewed this. It's denied. This case, we know for sure that she's not going to be testing positive. Well, it's almost certain she's not going to be testing positive while in jail. So is set for trial? Is that what we're gonna do?
Let me speak with Mr. Hager.
Terrence Lindbergh? Okay. Terrence Lindbergh, that's yours too.
Yes, sir.
Okay, I need Mr. Lindbergh. This is another interesting case. This is a bond attitude. Is that right? So, what are we doing tonight? He didn't show up for trial, so. 2-year-old baby.
2 years ago, I think apparently it took us so long to get him into custody.
Well, you don't know him?
I saw it on the docket. I wasn't familiar with why it was said. I thought it was an announcement saying actually. I didn't
Okay.
want to see it.
I think it
Threw off the trial 2 years ago. All of them speaking of Mr. Ham.
Okay, Gary Cooper Boudreau has been reset. That was Ryan's case. Christopher Allen. Miss McNally is on Christopher Allen.
I'll talk to you.
Yes, I have an offer on him, but if I can have 3 weeks just to continue to review that with him, I need to show him more.
It's 2 weeks good.
I would really love to read it if he could spare.
You would love to read it.
Would love.
You got it.
Thank you.
Christopher Allen reset 3 weeks for a disposition hearing.
One way or the other, Judge.
Yeah.
We will know what way.
Well, that's always inferred. Michael Best.
He is in Hardin County custody. He was picked up from Jefferson County Jail this past Friday, so he's not in our custody.
He's not there. Is that the best you can do for Michael? The best?
It's the best. Hopefully Hardin County can do something better.
It was a slam dunk. I just felt like I had to pull it off.
They softball the team,
It was a softball.
but he is in
Yeah,
Hardin County.
I hit that one hard. It just got it just out of the infield. All right. So Michael Best, we're going to reset
For review.
for review in 4. Is that going to be?
Sure, Judge. I mean, he's got a pending first-degree felony over there, so.
Is this all well, he's got an MTRP here. Let me see his phone. Thank you.
I believe there needs to be.
Be like 3rd here, huh?
Oh, no, it's a state jail felony.
Oh,
Oh, burglary of a building.
Judge.
I need to look at it first, real quickly.
Okay, well, I'll have to deal with that one.
It's a state jail felony of burglary of a building, but I think that there needs to be a new amended motion to revoke probation. I've talked to Danny about it. He's aware.
Who?
Danny,
Danny. Yes.
but
Danny Boy.
I doubt he will come back here until that is resolved. Given the.
You're
We'll
keeping
amend the
up.
MTRP, Your Honor, once we get all the offense information from.
What are the grounds of the MTRP?
Right now, they're just administrative. He basically absconded, didn't report employment, didn't report address change, he's behind on fees. But the motion to revoke probation was filed in February of 2024. I think that he was picked up for custody.
Coming up on 2 years.
I don't think that he was picked up until this past September, Judge. And then
That
Hardin
can't
County.
play out well. At
Hardin
the end of
County
this.
got
Okay. All right, let's review the status in
6 weeks.
6 weeks.
Okay.
Okay, thanks. It's in Hardin County. Is where it is. I have Watisha Jackson. That was RS.
Yes,
You call that
because-
All right.
reset?
Yeah, that was.
That is what's going on in Texas with Judge Stevens. We'll check back in with him in a little bit. I suppose we'll shift it a little bit further to the west. We'll head toward Bexar County, Texas. And here at TCF, we are committed to giving you at least 9 to 11% more of Judge Boyd. And so we're going to do that right now. Here is Judge Boyd. Is there not audio? Well, Judge Boyd is reviewing documents at the moment, but I think we should have audio, but she's not actually saying anything at this moment. So I am checking, but it looks like everything is working. Let's nudge this forward a little bit. Let's see. There. Well, something has happened to the audio. But I think we can fix that.
Is either going to end up going, based upon the TAP evaluation, he's either going to end up going to SATF or either he's going to be in the felony drug court. And what I can tell you is that it is rare that out of the gate, TAP evaluation, TAP recommends inpatient treatment.
Okay.
So you're going into custody today. And what I can tell you is that felony drug court will put in the request for a referral to felony drug court. They'll have him interviewed before the week is out. But you need to be honest with them about your alcohol issues. If you're not honest with them, you know what's going to end up happening. They're not going to accept you into the program. And then you're going to end up going to SATF because that's what TAP says. Felony drug court is an intensive program, but it's a great program. Okay. All right. This is what the court is, states you may be excused. All right. As previously stated, the court found you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 4 years. There's to be 10 days in the Bexar County Jail as a condition of probation. There's to be a referral to felony drug court. That's to be done in custody. If not accepted to felony drug court, then it will be SATF. There's to be $60 DPS for testing. There's to be no restitution. Ignition interlock for half the term. DWI intervention. VIP live. 2-year license suspension. 200 hours of community service restitution. 100 of those hours will be waived upon completion of parenting class. The remaining hours for every sober support meeting you do, an hour will be deducted from your community service restitution.
Judge, when you're done, he has a request.
All right. There's going to be field visits 1 time per month for 6 months. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release, no employment as a home health care provider or with minors. Probation, is there anything else? Yes, you had a request.
Yes, ma'am. My wife's legally blind right now, ma'am, and I'm the only one to help her with the kids. We don't got no support, ma'am. I don't know how she's gonna do it. I mean,
Mhm.
I'm the sole provider of the house, ma'am.
I understand that, and I understand what you're saying, and I want you to know that the problem, though, is that you're not a help to her or to a help to the children if you have an alcohol problem. And I mean, that's why we're here. And I don't know if you've read the police report recently, but the police report is very bad. And you were extremely intoxicated. And easily, your child could have been killed, or you could have killed someone else. So you're not of help with that. And I don't know the reason for your drinking to intoxication. I don't know if because you have a lot on you. I understand. You have a lot on you taking care of the children, a lot of you taking care of the wife, a lot on you with work. And maybe that's why you're self-medicating, but you're not going to be any good to them if you continue on this route, because either you're going to end up having some kind of alcohol related disease, or either next time you're going to be driving and you're going to kill somebody, and then you'll be going to prison potentially. So what you need to do is you need to be 100% honest with felony drug court. As I said, today is Monday. They'll see him before the week is out. I'm going to get the request from Miss Abrams. Probably within 5 minutes, I'm going to sign it, and she's going to email them and let them know to do an expedited one.
Appreciate it, Judge.
Right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what that is, you'll need to speak to an attorney. Do you understand? All right. And counsel, I'll make sure that they're aware of his situation and to do it expeditiously.
Thank you, Judge. I appreciate it.
All right. Thank you. All right. Good luck to you, sir.
All right. Good morning. It's the Courtroom Files Live. Boy, it is a Monday. We're turning a Monday into a Monday. Some technical issues this morning, but I think we've gotten those all kind of cleared up, and we're still on track. So I didn't touch anything. I don't know what happened. So, but we got it fixed. I've been I've only been doing this for 25 years, 27 years. So no big deal. Let's continue with Judge Boyd. Let's see what's going on here, as the next contestant will soon be coming on down. Maybe. Or not. Well, I suppose we can shift things up a little bit and we can go back over to Michigan. Let's see what's going on with Judge Dad.
6th at 9:30, okay? November 6th at 9:30 will be your court date. All right?
Can I ask, just to confirm, this is Eastern time, correct?
Yes, sir. Where do you live? Oh, you live in Ontario.
It's Alberta, actually.
Okay, okay. All right.
All right.
Okay.
Thanks so much.
Have a good day. We'll see you here then. Thank you. John James Schaefer, 25F 244-726. Your name?
John Schaefer.
All right, so you're gonna plead to no proof and you want time to pay, right? To the charge, no proof of insurance, responsible or not responsible?
Responsible, sir.
Plea is accepted. Do you have insurance now?
No, not yet. I just got a new job, so I was gonna ask you to wait a week, possibly two.
I don't have a problem with that. You can't drive without insurance. You get yourself in all kinds of trouble. You know what I mean?
I've noticed.
How much, so your total here is going to be 185. Tell me how much you can afford to pay.
I just started the job. I don't know if they hold my first check, so I was gonna ask for 14 days and I'll pay the whole sum.
All right, I'll tell you what, I'll just give you until November the 20th to pay it in full. How's that?
That's amazing, sir. Thank you.
If you need more time because you don't have the money, you call the court. We'll go on Zoom. I'll give you an extension, okay?
Thank you very much, sir. Have a great day.
You too. Thanks a lot. Damian Lee Edwards, 25W840083. Do you have that? I think you need to tell me whether there's injuries or.
Yeah, that's what I knew that was a mistake. I just didn't know if
Okay.
there was an impeding traffic that was already issued in the past or not. That's what I'm trouble reading right here.
Yeah, all I need to know is if there was injuries or serious damage.
No injuries, minor damage.
Okay. Your name, sir?
Daniel Lambert.
Good morning to you. You're going to plead to impeding traffic, right?
Yes, sir.
And then they're going to dismiss the speed, right?
Mhm.
Yes?
Yes, sir.
All right, this is a commercial motor vehicle, right?
Yes, sir.
Charge impeding traffic, responsible or not responsible?
Possible.
All right, 180 is your total. Cashier under the hall. You're all set. Good luck.
Thank you. Have a good day.
You're welcome. Joshua Evan Worthy, 25W838369. Good morning, sir. Your name? So you're gonna plead to minor damage, no injuries, you can plead impeding traffic, right? Responsible and not responsible. Plea is accepted, initial charge dismissed, 195 is your total, you're all set.
Thank you.
Have a good day. Amanda Dawn Igna, 25B149457. Your name, ma'am? All right, so you're going to plead to impeding. It says two vehicle crash, no injuries, minor damages. So I'll take that to that charge of impeding traffic, responsible or not responsible. All right, I'll accept the plea, dismiss the original charge, 195, you're all set. Sorry to keep you waiting. I had to check on you, okay?
Thank you.
David Scott Morton Jr. Is David Scott Morton Jr. here? Rachel Marie Giles, 25B149683.
Rachel Giles.
All right, so you're gonna plead to impeding traffic, right? Responsible or not responsible?
Responsible.
They got you going 50 and a 30 in a school zone. Please slow down, okay? All right, 155 is your total. You got a good record though. You're all set. Original charge is dismissed, 155. Thank you. Is David Scott Morton Jr. here?
It's the courtroom files. It's Monday. Oh, it's Monday. I'm Michael Groff filling in for Dan Soul.
All right,
Then
Raniker.
we're
Eric
dealing
Stephen
with
Raniker, 25B1496.
we're dealing with a few technical issues, but we're working through it. Let's keep it going with Judge McNally here for a bit.
Good morning. Your name?
Eric Harrison.
All right, so you're gonna plead to impeding, right? Responsible or not responsible? Please accept it's the original charge dismissed 150. You're all set. Have a good day. Willie Johnson third rather. Willie Johnson the third, 25F 24559. Your name, sir? You're gonna plead to no proof of insurance, right? All right, you have insurance now?
Yeah.
Okay, to the charge of no proof of insurance, responsible or not responsible. All right, I'll cut it down for you to 145. Please accept it. And then you tell me when you can pay this. You need to set up a weekly plan or are you gonna pay it in full? How much? Where do you work?
I'm laid off right now.
Pay 40 per week. Beginning November 10th. Is that good?
Sure.
If you don't have the money at any time, you call the court, we'll go on Zoom. I'll give you an extension. Okay? Best of luck. Carter Ashton Gardot. 25. 2840000. Your name?
Carter Gardot.
All right, Mr. Glowacki. What are you dragging like this for? You're 17?
Yeah.
Gonna slow down, be careful. Are you a junior or senior?
Senior.
All right. Cars are not toys, okay? To the charge impeding responsible or not responsible. Please accept at 150. Thank you.
Thank you.
Sergeant, I'm sorry, Lieutenant? Sergeant,
Yes,
would you remind everybody to come in? I don't know where some of these people.
yes, I was talking, Mr. Morton's in here now.
What are they?
He was, I think he's a Woodhaven case, but
Yeah, there's another one that they didn't come in. Edna, if you could kind of remind those guys,
okay.
just to tell them, I don't know why anybody would not come in court, but that's fine.
Yes, Your Honor.
Thank you. David Morton, David Scott Morton Jr., 25B149594. How you doing, Mr. Morton? Your name? All right, please be careful, will you? To the charge, if you're going to plead to impeding, the speed will be dismissed, right?
Yes, sir.
To that charge, responsible or not responsible? Please accept it, speed's dismissed, 155, you're all set. Good luck. William Thomas Hopper, 25W840100. Good morning. Your name?
William Thomas.
So you met with the department rep, you're going to plead to impeding, right?
Yes, sir.
Responsible or not responsible to that? All right. 175, you're all set.
Thank you, sir.
All right,
you.
Judge McNally is on the lightning round right now. That's good. Good to see what's going on up there. All right, well, we haven't checked in a while on Judge Middleton. And as you know, or maybe you don't know, we only have a year and a couple of months left of Judge Middleton, and then he is termed out. And I don't know, we here at TCF, we love Judge Middleton, so let's go there right now and see what's going on in St. Joe County. There we go.
Well, the esteemed Michael Kirschenheiter is here on behalf of the plaintiff Jefferson Capital. You can't see him, but he can hear you. Okay. The title of the case is Jefferson Capital Systems versus Crystal Ellis. The file number is 25950GC. The claim is not substantial. It's $633.40 plus cost, interest, and attorney fees. Yes, Ms. Ellis has filed an answer indicating she'd like to set up a repayment plan. She's offering $15 a month That's not very much. It'd take 4.5 years or more to pay off the debt at that rate. Are you willing to speak in a breakout room with Mr. Kirschenheiter to discuss possible settlement of the case?
Yeah.
All right, it should put you in automatically with a telephone, at least I hope it does. So I'm gonna put you in the breakout room and you can speak privately with the attorney on behalf of the plaintiff.
Thanks, Judge.
All right, thanks. As I indicated, our next matter has resolved with the consent. So I will stick around until 10, but that won't take very long, if any time at all. That will finish our 8 pretrials. I can't believe Judge Pattis had 11 drunk driving arraignments.
Right, it's TCF Live. It is Monday, the 27th of October. My name is Michael Groff. I'm sitting in for Dan Soul over the next couple of weeks, and I know, you're like, oh my goodness, this guy for 2 weeks. Yeah, well, hey, we're having fun. It's substitute teacher time. We're still getting through it here, and hopefully you are enjoying whatever it is we're doing here this morning. No, but thank you so much for hanging out with me and your patience, because sometimes this stuff, well, it can be a little bit tricky to navigate. And so we will we'll continue to persevere. All right, let's see what is going on in Texas. We'll head back to Judge Stevens. We'll see what he's got going on. Looks like another defendant is coming on down. Let me head on over there. Best I can here. There we go. That's not my audio this time. Stevens is... He's working here. There we go. Sometimes he likes to mute himself for a minute, but he was just talking, I assure you.
In summary, paragraph 1 alleges that on or about October 29th, 2023 in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. Do you understand fully what you're charged with? Paragraph 2 goes on to allege 3 or more prior operating motor vehicles in public places while intoxicated convictions out of Harris County in 2004, out of Category Law 2 of Fort Bend County in 2005, and in 2015, this Criminal District Court of Jefferson County, Texas. Do you understand what you're charged with here in paragraph 2? You understand that paragraphs 1 and 2 constitute a 3rd-degree felony, which means you are looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
2 to 10.
How do you plead to paragraphs 1 and 2, guilty or not guilty? Huh? Are you pleading guilty voluntarily and because those allegations are true? And paragraph 2, which alleges those prior convictions, are those all true and correct as they are alleged? Are you pleading true and correct to those allegations voluntarily and because they are true. You know. And are you pleading guilty and true to paragraphs 1 and 2 voluntarily? And because those allegations are true, sir. I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it. Discuss it with your attorney. Are the contents all true and correct? State's Exhibit 1 tendered into evidence. Without objection, it's admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, consultation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is part of the record for all purposes. Is a pre-sentence report waived to you?
Yes, Judge.
I am going to follow this agreement, if nothing further to add by the parties, and find you are, Mr. Kearney, pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of paragraphs 1 and 2. Constituting the third degree felony of operating a motor vehicle in a public place while intoxicated with 2 or more prior convictions. And I hereby find you guilty beyond a reasonable doubt. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve and that will be suspended. You will post on regular probation for 10 years. There will be terms and conditions of probation which are normal and customary for this type of offense. And
What's that? We need to fill in the end stack of Middleton.
if you happen to hear what I was talking about.
No, sir.
Full and complete.
Nope, look like Judge muted. Well, if I'm following that correctly, that is his 4th DUI conviction. And he is getting 10 years of probation for 4th DUI conviction. Well, all right. And if you thought Texas was rough on DUIs, maybe not so much. But let's see if Judge decides to unmute here. Again, this is not my muting. Sometimes Judge Stevens does this. He mutes for a minute and then he'll come back. So we'll just kind of vamp for a moment and we'll see what happens. But 4 DUI convictions in 10 years, regular probation. Let me know what you think about that in the chat. All right, very poetic. Now let's see if Judge comes back. This is Dan's biggest pet peeve as well. Sometimes Judge will mute, he'll forget to unmute, and then the rest of his day will be completely muted. So this can happen with Judge Stevens. Maybe it doesn't. Let's see. Looks like maybe he did. Doggone it, Judge. Consarn it. What are you doing? Tell you what, I think we're still in the Wayback Machine here just a little bit. We'll nudge it forward. We'll see if he unmutes. He did not. Excellent. All right. Well, with that having been said then, since Judge did not want to unmute for us, if it's not one thing, it's another. Hey, it's a Monday. Oh, there he is. Judge, you're going to make a liar out of me. All right.
Okay. I need Mr. Files.
Yes, sir.
Kyle Mulholland. We'll need Kyle Mulholland, please. Thank you. That does not surprise me. You want my signature or somebody else's?
It's not, so you're coming up. Want to put mine on there?
Sure. Where? Let's defend it in the community.
Maybe I'm You made a mistake. Well, it's.
By the way, while we're waiting for the next contestant to come on down, check out the Courtroom Files. Not only our, courtroomfiles.com for all your Courtroom Files merch. Lots of great stuff over there. Great way to support the channel. If you want to help us out, get a channel membership. You can join us for the pre-show. Dan will still be here. He's not completely gone. He's on the pre-show. Depending on road conditions, he is traveling, but he will be joining us for the pre-show most days, internet pending. And so you can check that out. So I highly suggest you become a channel member. It is just $2.99 a month. It's really the best value on all of YouTube. You won't get that from Mr. Beast, that's for sure. All right, let's continue with Judge.
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Good night, Judge.
I've got two paragraphs here. Do I go one or just both?
Well, this agreement you're on is to the lesser included offense. So those are detailed paragraphs 2 and 3. So
what
stage?
One and two are required for the continuous.
Yes, sir.
Sexual assault.
Yes,
or
sir.
sexual abuse. So we're only going on one. Is that right?
We're proceeding on the lesser included offense of aggravated sexual assault of a child. Your Honor will need to.
Well, I mean, we only need paragraph in one, right?
Yes, sir. And we can just take out of that the 30-day language of 2 or more acts. A cleaner way to do it would be to stop at where it says in the County of Jefferson, State of Texas, comma, is to stop there and jump down to the second paragraph and have it lead to that.
Go over that one more time. Follow it.
For the lesser included offense, my suggestion would be to reading from the indictment on the 5th line where it reads indictment in the County of Jefferson, State of Texas, stop at the comma, go down to the second paragraph. And that would be the elements that are needed for the lesser included offense of aggravated sexual assault of a child. Because how it's detailed is the 2 different matters that are necessary to occur within the 30 days, Judge. Hopefully I didn't complicate it too much saying that.
I'm bonded with jumping from one paragraph. Okay.
All right.
We should do paragraph 1, lesser included. It's included. It is also included in paragraph 1 by intentionally knowingly causing sexual organs of contact and penetrate the sexual organ of the child.
All right, so we're gonna
That is aggravated sexual assault is what you're intending to prosecute him on, right?
Judge, if we're gonna stick with paragraph one, we would omit picking up with during.
But isn't paragraph one, the lesser included from paragraph one that y'all move on? Isn't it within that paragraph? Okay, let's, I don't think we need to delete anything. I think it just, we go, we proceed on the lesser included. Offense,
Yes, sir.
aggravated sexual assault, correct? Which is a first.
Yes, sir.
And that's the regular probation, regular punishment of no less than 5, no more than 99. It's normal first degree felony punishment.
Yes, sir.
Okay. In summary, sir, and we can proceed in summary and wait so far.
Yes, Judge.
Reading Mr. Turk on behalf of Mr. Mulholland. Paragraph one alleges that on or about December 31st, 2018 in Jefferson County, Texas, you committed the first degree felony of sexual abuse of a child, continuous sexual abuse of a child under 14. Do you understand what you're charged with in this paragraph one? The agreement has been reached by the parties that you will be prosecuted on the lesser included offense of sexual assault, of aggravated sexual assault of a child, which is a first degree felony, which carries with it no less than 5, no more than 99 years confinement in prison or life imprisonment, and a fine up to $10,000 can be assessed. Do you understand the punishment range and the plan that has been
Yes, sir.
prepared in this case and agreed upon, that you would be pleading to this lesser included first degree felony?
Yes, sir.
I had to let John have it, so I didn't have it just now. With a flat right here. Think that we're not gonna have it. That's the dimension that's right there. Okay. English has to go.
An agreement's been reached furthermore that you would be pleading guilty to this lesser included first degree felony of aggravated sexual assault of a child, and you will be sentenced to 20 years in prison. Is that your which will run concurrently with other cases? Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Understand.
How do you plead to this lesser included first degree? Hold on. The lesser included first degree felony of aggravated sexual assault of a child as indicted in this case, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
Show you what's marked here, states exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true, correct? States exhibit 1 tendered into evidence.
No objection.
Without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses such as this one you were pleading guilty to in this particular case of aggravated sexual assault under this indictment, charging you with continuous sexual assault of a child under 14. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
I'm going to follow this agreement, sir. If nothing further to add, and find you are pleading guilty voluntarily, knowingly, intelligently to this lesser included first-degree felony of aggravated sexual assault of a child in this indictment. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting the guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of this offense, this lesser included first-degree felony of aggravated sexual assault of a child. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 20 years in prison. Also, do you understand a conviction or adjudication of such a crime such as this requires you to register in the sex offender registration program, sir?
Yes, sir.
And I'm showing you a document that has been signed. Is that your signature?
Yes.
Did you understand it? Discuss it with your attorney, Mr. Turk? Is everything true and correct?
Yes, sir.
All right. The sex offender registration admonishment dated on this date of the 22nd of October.
It's the 7th.
27th October 2025. I can't read this stuff. You guys are beginning to write like doctors. All right. It states that you understand you have a reportable conviction of aggravated sexual assault. That means that you are required to register in the sex offender registration program. You understand that you must comply with Chapter 62 of the Texas Code of Criminal Procedure, sex offender registration requirements. Failing to proper register is a criminal offense that may result in your prosecution. Do you understand?
Yes, sir.
If you move to another state that has similar reporting requirements for sex offenders, you must register in that state. Failing to register can result in you being charged with another criminal offense. Do you understand the reporting requirements you have here, sir?
Yes, sir.
Is there anything else to add here? All right, then that is all. Thank you.
Thank you, Judge.
Oh boy, 20 years on a lesser included offense of that. All right, so that's what's going on over there in Judge Stevens' court. And of course, we're going to keep an eye on that. Courts have gone a little bit quiet here as we head deeper into the morning, but we still have a bunch going on out there. Again, welcome everybody. The Courtroom Files Live. It's a Monday, and we're hanging out, getting through it the best I can. Michael Groff in for Dan Soul. And let's see what's going on with Judge Boyd.
Edward Valdez.
Yes, we conferred with the state.
All right. Court is calling DC 2023 CR 7270A State versus Edward Valdez. Could I have parties announced for the record?
Amir Memori for Mr. Valdez, Your Honor.
And are you Mr. Valdez? All right. You're requesting a bond for your client. Is that correct?
Yes, Your Honor.
And a warrant was issued on September 11th, 2025. The defendant did not appear for court, and that warrant was issued by Judge Angelini.
Yes, Your Honor.
Any questions for your client? Like, why wasn't he here? What type of bond can he make? You'll need to be placed under oath. You raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you may state your name for the record.
Edward Valdez,
All right, so what questions do you have?
Why were you not in court on that?
because I didn't know if I had court date or anything. They never approached me to my house or the phone that I gave. I was always working, so I couldn't. If not, I would have gone or called if I wouldn't have made it.
So you've been accepted into the PTD program, correct?
Mhm.
We've signed the agreement, correct?
Yes, sir.
At this point, how much bond can you afford to get out?
be honest with you, I've been incarcerated since August, so I'm not sure.
Wait, you're saying you've been in custody since August? Well, the warrant wasn't issued till September 11th. Why were you in custody?
Because I had warrants, I had 2 warrants.
No, but what I'm saying, your warrant wasn't issued until September. So you shouldn't have been in custody in August because there was no warrant. What was the warrant for?
It was a misdemeanor MTR. Get a case out of county court, 7 judge.
All right, so he had a case out of County Court 7, and what was that case for?
ABI, family violence judge, and the MTR, he had an MTR on that case.
All right, any other questions?
Not for me, Judge. If you have any questions, please.
All right, state any questions? All right, when's the last time you were employed?
The last time I was employed, it was in BJ's, before I got locked up.
All right. And what was your salary or pay per hour?
$15.
Have you ever had any previous mental health issues?
Oh, man.
Have you ever been diagnosed with any type of mental health issues? Have you ever used any type of drugs in the past? And this motion to revoke on the family violence case, the misdemeanor, when was that?
Judge, that was, I believe we resolved that on October the 9th, Judge.
And who is the complainant?
That was the MTR, Judge, just to let you know.
Does he have a no contact order with the complainant? Who is the complainant? What's the complainant's name? All right, do you reside by yourself?
Oh, was that me?
Oh, do you live in a home by yourself or there are other people who live with you? I'm sorry?
With my wife,
And who is your wife?
Sylvia Martinez. I've been living with her since that incident. But since I got locked up, I don't know where I stand now,
Okay.
to be honest with you.
And are there any children in the household?
2,
What are their ages?
15 and 12.
All right. State, what are you requesting as a bond amount?
And we're requesting 1,000, Judge.
All right, the court is going to set your bond at $5,000. All right, is there anything else?
No, Judge.
All right, your bond will be set at $5,000. Yes.
Thank you.
Appreciate you. Have a good day.
Have a seat, sir.
It's the Courtroom Files Live. It's a Monday. We're hanging out with Judge Boyd here, and we'll see if she has someone else coming up. Want to take this opportunity to thank Grandma TCF for $10 and Bailey $1.99. The super chats, those super stickers, they do go to me in this 2-week period where I am filling in for Dan. So if you want to get Dan back here sooner, best way to do that, probably throw a few more bucks into the super chats and super stickers or
Raymond Diaz.
what have you, but we'll continue with Judge Boyd.
Morning.
Also, we could buy better equipment with those, with the super chats and super stickers. So there you go.
Mr. Raymond.
Anyway, back to Judge.
All right, so where are we on discovery?
I conferred with Ms. Jones this morning. I don't really have too much of it. So what I asked her if I could do is bring her a flash drive, get it all uploaded on there.
Mhm.
And then hopefully on the next setting, we can be ready to talk about offers and that kind of stuff.
All right, is there CPS records?
Here, it's your honor.
And I have a motion for that. I don't know if you want to take it up now.
Yes.
Okay.
Where's the,
And your honor, the state will order and give them over to defense with flash drive.
all right, so if you all will give me that protective order, please. Is there anything else?
No, Your Honor.
All right, Ms. Ferguson, I need a reset date for discovery, 30 days. All right, we'll see you back on December 4th.
Okay.
All right, thank you.
Have a seat, sir.
All right. Anyone else? Antonio Barrera. And where is he?
He's not present, Judge.
All right, Deputy Laura, if you can make an announcement, please. Court is calling 2025 CR 007-001, State versus Antonio Salinas Barrera Jr. Can I have parties announced?
Defendant for the state of Texas.
Bridget Garza for defense.
All right, this hearing was scheduled at 9 a.m. It is now 10:24 a.m. The defendant has not answered the docket. Defense, have you had any contact with your client?
No, I have not, Judge.
There's silence as we wait for her to come back. We're gonna part the waters. Deputy Laura, did you make an announcement?
Yes, when I did, it's not out there.
All right, state your request.
Forfeit the bond issue, the judge more.
All right. The court will issue a bond forfeiture, remand your client without bond. If your client makes an appearance, the court will reconsider.
Okay, thank you, Judge.
Show up for court. It's the easiest thing you can do. Report on probation, show up for court. The two easiest things you can do, and it's amazing how many people do not. They abscond.
All right, who else?
And then their bond gets forfeited.
Michelle Battles. Michelle Battles. All right, who's next?
Your Honor, may I have this quickly?
Yes, thank you.
Thank you, Judge.
Could be.
Thank you.
Take care. We'll keep talking. Thank you very much.
Sure. All right, who else?
Mr. Leo, are you ready? Not yet. Oh,
Well,
we haven't confirmed yet. Okay. We have nobody. We're ready to please.
Oh,
I'm gonna sign out.
all right.
All right. Well, it looks like Judge Boyd is waiting on some other people to get things going there. So we will, of course, we're going to keep an eye on what's going on. Kind of doing the Texas two-step here. We'll just keep kind of ping-ponging back and forth because there's quite a bit of action going on. And Texas seems to have some, well, some interesting cases today. And dare we do it? I guess we'll go back to Judge Stevens and see what's happening over here. I don't know. Stepped on a landmine a minute ago.
Restitution.
Yep, you're right.
Restitution of these. Notice 368.
You can up one more time. Please, right there. Actually, just make another job.
Or whatever.
And we now call 25 CR 509, the state of Texas versus Gregory Patrick Woods. That is you, sir. Present with Mr. Perk, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
We may just.
In summary, sir, this indictment alleges that on or about August 15th, 2024 in Jefferson County, Texas, is alleged that you committed the third-degree felony of credit or debit card abuse, as it is further alleged that you committed the offense against an elderly individual 65 years of age or older. Do you understand what you are charged with here?
Yes, sir.
If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? The agreement's been reached. You would be pleading guilty. Whatever sentence shall not exceed a cap of 5 years in prison. So you are looking at no less than 2 nor more than 5 years in prison. You could be placed on deferred or unadjudicated probation. Also, you could be placed on regular probation. Is that right? Is he eligible for me for regular? I think
My head, I'll shoot.
I think he is.
He's eligible.
He's
just
eligible for
benefits.
me, not
Yes,
maybe
sir.
a jury, but.
He's not eligible from a jury, but he is from you, Judge.
So you could be sentenced to no less than 2 nor more than 5 years confinement in prison. And that could be suspended. You could be placed on regular probation for up to 10 years in police. And there would be terms and conditions of probation which are normal and customary. I see there's restitution in the amount of $1,537.68. Is
That
that
should
right?
be $31.68, and the
That's like
parties.
a 7. Okay.
Sorry, that's my handwriting, Judge.
Is it 31 or 30?
31.
31.
This might be 3168. Sorry, I know that.
Am I? How do you know that?
Is that what you understand, that there's a loss here, sir?
Yes.
Oh. If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this charge, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents offered incorrect?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection?
No objection.
Admitted. Among other things, the state you are mentally competent to enter your guilty plea freely and voluntarily made, you know what you've been charged with. The indictment's going to let you, and you've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes.
Absolutely.
Is a pre-sentence report waived, or do you want a pre-sentence report on this?
Uh,
I can listen to arguments from the side, from the parties, but what do y'all want?
Our intention was to ask for a PSI, Judge.
Okay, what's the state going to be asking for in this?
Well, and the benefit of the PSI is it'll confirm.
You're waiting for a pre-sentence report to make a final decision.
It's
right?
going to confirm
Okay.
his criminal record that we want the court to be advised about.
We will then defer further findings, order a pre-sentence report. When can we come back?
First week in December.
Is that going to be good? 5 weeks? Okay, thank you. Probation. We'll come back in 5 weeks, and then all parties can present any additional information, and then the court will make its decision. All right. Thank you. Also, this restitution. Or you, I know you're in custody, or can you or someone on your behalf help you pay this restitution back as soon as possible? That makes a big difference to this court.
Yeah, well, recently I was just, car accident, so I should be getting my social security as soon as I get out.
So you have
Oh.
a source of income. Source of income.
Yeah, that's gonna be my social security.
So this
Right.
this is again $1,531 and some change. How long do you think it would take you to get that paid back?
About a month or two, 2 months.
A month or two?
Yeah.
Without making your life harsh, like when you give it a leave.
2 months.
Okay.
You sure?
Yes, sir.
Okay. All right. That, if the court puts you on probation, I'm going to give you maybe, 3 months just to be on the safe side, but that would be important. And if you fail, your probation could be revoked and you could be sentenced up to the full range if I place you on probation. Okay. Because that's what I want these people, the victims, paid back as soon as possible. Anything else? Okay, we'll see you back in 5 weeks.
It's TCF Live on a Monday. Once again, thank you everybody for joining me. Want to take this opportunity to thank Bailey and Barbara for donating a channel membership. Really helps out the channel, keeps things going here. We just passed 27,000 subs here on TCF. And want to thank Barbara for another $5 super chat, super sticker, all that stuff. Thank you. Really do appreciate it. Back to Judge.
Yeah. Rodney Paddy, please, thank you.
Oh, I remember this. That's yeah.
Yeah, I have several dismissals on Donna Arnold.
There's two on there. There's gonna be a plea on one, Judge.
Thank you very much.
I sent you two dismissals that are conditioned upon the plea, Judge.
You did see one. Okay.
Which one?
Okay, see her? Thank you.
Rachel, are you please swear or affirm to tell the truth, the truth, and nothing but the truth, so help you God? Thank you for your right hand print. Place it flat right there.
Are you sure?
Flat, don't roll it.
That's the one we just.
Flat, don't roll it.
Yeah.
Famous words. Flat, don't roll it.
Say it a million times a day. You can go say it for again.
Right here, sir. Thank you. You or Rodney Eugene Petty.
Yes, sir.
Correct. We call 25 CR 1224, the state of Texas versus Mr. Petty, who is present with Mr. West, his attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges on or about August 11th, 2025 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon. Do you understand what you were charged with here, sir?
Yes, sir.
This is gotcha.
If convicted of a second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
What's the update on new pads?
They've been ordered.
It works.
I understand, Judge. I do know the new pads have been ordered,
Frustrating
but
because
their
half of this,
current shipping status, I'm not privy to that information.
just half of what I'm writing is showing up and I have to rewrite it over.
It took about 45 years to get that going earlier. The problem with getting the teacher.
That's about what Wright Kindler tells us to get going on this. About the same. An agreement has been reached, sir. You would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, and fined $500. Is that your understanding? Yes, sir. If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will.
Yes.
And because you are guilty. Let me show you, it's marked. Well, State's Exhibit 1, did you sign that document voluntarily? Understanding this, that's it, your attorney, is the contents all true and correct?
Yes, sir.
State's Exhibit 1, tended into.
No objection.
Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea. Freely and voluntarily made, you know what you've been charged with, that's with you, you've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Deferred.
Yes. And the plan is you're going to be pleading guilty based on deferred or unadjudicated probation for 10 years. You do well, I'll shorten it to 1/3 of it. Fine $500. Is there any restitution here?
Not that I know of. No.
Is that your understanding of the plan?
Yes, sir.
All right. Anything else to add?
Nothing much, Your Honor.
If nothing further, I'm going to follow this agreement and find you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense, including you must pay a fine of $500. And then there will be an anger management program that we are going to ask you to or order you to take and complete. That's a good thing. It always helps you try to think ahead a little bit about what the next action you take and how that might adversely affect the rest of your life.
Can I add something?
Yeah, go ahead. I don't never know what's about to happen, but
I'm only going to the Dream Center. And
Sir?
the Dream Center,
nobody stops you from doing that.
I'll be able to do that with being on probation and still do my classes.
If they allow you to, yeah, but that's going to be your choice. I'm going to be giving you other terms and conditions of probation, but whatever you feel like can help you be the best person you can be, do it.
Yeah, that work.
You gotta be careful on this. If the probation can be revoked, and
Yes, sir.
then I can then find you guilty, and then you can be sentenced up to 20 years in prison. And this includes a deadly weapon, a metal rod, as the item used in the aggravated assault as a deadly weapon. So if you were sentenced to 20 years, you'd have to serve 10 before you're parolable. So there's a lot riding on you doing the right thing. And here's what's ironic here. You know, this isn't like punishment. These are most of these requirements are what we all have to do properly to conduct ourselves every day. Like commit no offense, don't associate with disreputable people, support your dependents. I mean, dress appropriately, conduct yourself properly. I mean, what's see, for everybody should follow these. You know. So there are some that are particular. Well, much of this is just getting you back on the track. Sure. All right, you understand what happened today here, Mr. Petty? Please see the probation office.
Wahoo,
Milton
thank you
Richard?
for the $5. Really do appreciate that. That helps out big time. Of course, if you want to join us in the chat, hang out. Always great to see you here at TCF Live. We have the best community in all of LawTube. I don't just say that because I'm part of the community or because I'm filling and hosting this show, but because I really do believe it. I would not be here if I didn't see that and experience that for myself. So let's head back up to Michigan. I saw Judge Shackelford had a case going on up here, and it looks like this particular defendant allegedly has quite the laundry list of, quite the litany of a criminal history. So let's see what's going on here. We don't get to see Judge Shackelford very often, so always good to see some of the more rare judges here on TCF. So let's check out what Judge got going on. Of course, when I go to her, I saw this a moment ago and muted, but not me. I know Wahoo says in the chat, you're doing such a good job, Mike. Well, yes, until this. But again, I didn't do it. Did we lose audio again? Really? We did? Okay. Well, that is not all right. Let me fix that so you can hear this case. And I'm going to fix that right this moment. Don't you folks worry a thing. All right. My apologies. I don't know. There's buggy stuff that happens. Let me go back to the big view here so you can see what I'm up to. A little behind the scenes stuff going on right now. And I am going to click this, and we're going to go over here, and we're going to add. Let's see. Judge Boyd. I had Judge Shackelford up here. Let's try now. Let's see if we can get this to work. Come on now. Come on, Bessie. I think that's what I've unofficially named this computer now, is Bessie. Come on. Come on now. All right, there we go. There we go.
And he did attend and complete treatment court in circuit court in 23. And I would ask the court to consider allowing him to be placed on probation. Again, this is a 3-year-old offense.
No.
And prove that he's worthy of the probationary period. He's willing to. I think the issue in the interview, he understood about going to treatment, meaning inpatient. I don't think Mr. Purdue would qualify for inpatient at this point, but he would certainly have no objection to probation with even if it was like under ISP.
Are any of these, I have never, like, this is the law. Your first criminal offense was the year I graduated high school. And then you had one, and you probably did some time on that one. And as soon as you got out, you picked up 1, 2, 3, 4 more. 4 in 99, 4 in 2000, 2001, 2002, 2005, 7, 8, 10, 11, 11, 12, 13, 13, 14, 14, 15, 16, 18, 20, 20. I mean, I've never seen a criminal history take up the whole front page of a PSI. I've never seen that before.
They were all retail fraud, and I was going through a rough patch in life. I was substance abuse.
So let me ask this, Ms. Hat, but the problem is you didn't go to any of the AA meetings. So like when you're on bond, listen, when you're on bond conditions, right, pending sentencing, one of the things I look at when I'm determining about whether or not you're a good candidate for probation is if you comply with bond conditions. And he hasn't gone to any meetings.
I wasn't told nothing about no.
Yo, yeah, you were. We'll find the record. I guarantee I said it.
All I was told was put on a teller. The alcohol.
I promise you. I promise you. I can pull up the record because I have a little sheet here where I check off all the boxes when I arraign someone, and that would have been a requirement. But listen, Ms. Hacker, he finished treatment court in 2020. Was that for this 2023 offense?
I finished at 23.
It was a 2020 offense, Judge.
So we picked up another controlled substance case in 2023.
Yeah.
After he finished treatment court.
Yes.
That's why I deem he's not appropriate, because he's even incurred new charges since this offense. He keeps incurring charges. So that's
And then
why-
I mean, we're not talking about a jaywalking.
Yeah, the cases are all.
Hold on.
And just so the court's aware, that 2023 case is another case that was laid out pending.
But it happened after he finished treatment court.
If there's no conviction associated with it. He's, I think he just got bound over in September.
Both of the cases they let me kind of have no idea of the case. They both incidents occurred. They wrote me tickets and cut me loose. I didn't go see no judge.
He's talking about This one, which was May of 22, and the one that's pending now was in November of 23. They did not,
They did not.
They were in that pile that
Gave me a court.
He just picked up in Redford in 2025. I see another one that's not even, I mean, there's, Miss Hapner probably didn't put it on here because there wasn't any room, but he's got another warrant pending out of Redford in August of 2025. So just like 2 months ago.
Because that's how I became aware of these offenses. It was the driving. I was driving.
That's not what this says. This says it was a public order crime,
So
misdemeanor.
it was tickets. I was driving on Telegraph. I got pulled over, and that's when the OWI and the other both tickets popped up. I was driving, bringing my baby mom.
Ms. Hapner, anything else?
No, Judge, I mean, I will turn to my recommendation. I do not view him as a good candidate for probation due to, just non-compliance. I mean, he keeps incurring criminal charges.
Yeah, I mean, he's picked up new cases since he's been on bond here. And he's completed a treatment court program and he continues to pick up new cases. So I don't think he's probation eligible. He's got all these cases. And a controlled substance, a disorderly person, and some other public offense out of record. Those have occurred since he completed treatment court, and 2 of them are since he's been on bond here. I mean, I don't know what to say. Anything else?
I haven't caught anything on bond.
Since you've been on bond?
I haven't caught any case on bond.
Yeah, what time? You were arraigned in 2024, the first time. And in December of 2024, according to your history, you picked up a case since then.
Each bond that I have given personals, and the only thing I have received is traffic violations. I haven't caught in any cases, Your Honor. Everything that is on me now is, 2 to 3 year old cases. But since those cases, I haven't came in contact with the police only due to driving.
Anything else, Mr. Fanto?
If the court's inclined to place Mr. Purdue in custody, I'd ask for something less. He has 67 days. I'd ask for something less. Again, this is a 2022 matter.
So you have state costs of 50, a crime victim's rights fee is 75. The warrant fee and the clearance fee are being waived, statute fee. So that brings you have 125 that you owe. And those 2 are mandated by the state of Michigan. You have 70 days in jail, credit 26.
That is quite the criminal history. Goodness. All right. Well, at least he hasn't been picking up many cases lately, so that's a feather in his cap, I suppose. That's Judge Shackelford. I just thought I'd present you that case because I thought that was very interesting. Lindsay, by the way, thank you for the $20 with the note that that's for the next Canes trip. Michelle and I will appreciate that. Michelle, who is our executive producer of the Phoenix, Arizona weather discussion, and of course will be helping out in Dan's absence over the next couple of weeks. So really do appreciate that. All those super chats and super stickers really does help us out and keeps things going. Let's head up to Wisconsin. Oh, yeah. Let's see what's going on there with Judge Morgan. Yeah, she's probably got something going on today. That was short and sweet. Let's see what else Judge Morgan's got going up there now. You betcha. Do we lose audio again? Really? Okay. I don't know why that happens. All right. One moment. I promise I will fix it. Let me do this. I don't want to entirely blame all the equipment, but I will partially blame the equipment. All right, let's see. All I do here is I turn this down. Let me turn down my monitor because that. All I have to do, you have to also forgive me. I am legally blind trying to run equipment, which always makes live stuff even more fun. When the blind guy breaks stuff, that's always good. So what we do is we just click on this and we click on this. We go back over here and we do this. See, this is, you can tell I'm a total professional, guys. I really am. I swear. We've got, let's see, got that. Just wanted to go back over here to Judge Morgan. I swear it was just here. Come on now, Wisconsin. Don't let me down now. There we go. Got it. Let's go back to Judge Morgan.
We're here today on Mr. Philippi's request for a bond modification. We have Assistant District Attorney Jose Villa in person, Mr. Philippi by video conferencing in custody in Burnett County Jail. Mr. Philippi, you have asked for a bond modification. You have been set at $1,000 cash. Anything else you want to argue as it relates to your request for a modification?
Well, I did ask for a bond modification before I found out that I was getting revocated.
Okay, so you're being revoked, so this technically really doesn't matter, and it would be in your benefit to have a cash.
Yes.
So you are being revoked,
I'm trying to fight my revocation.
and that's all I need to know. So I believe that you have another hearing date scheduled, or it should be scheduled if matter is going to be filed. So as it relates to your bond modification, I'm just going to deny that straight out. You're being revoked, and quite honestly, cash on you will give you jail credit instead of not. So. All right.
Did you get my application, attorney?
Your application, I have not received that yet. Once I do, I will be right on that. Okay.
Okay. I didn't know if you could possibly appoint me an attorney today.
You would need money down, as you did the last time, but I will look.
Like right now, I'm currently incarcerated and I can't make any money.
I will have to look at your application. I don't have it right now, and I will have to figure it out. Okay. All right. Thank you.
Thank you.
We will go on the record in the matter 17 CF 244, State of Wisconsin versus Ralph Kraft. The state is here through Assistant District Attorney Jose Villa. In person, we have Ralph Kraft appearing by video conferencing from the Chippewa County Jail. We are set for a request on your delinquent fines and fees. What are you asking of the court, Mr. Kraft?
I don't know.
I wrote a little list, okay? Well, first, I'm sorry, and
I can't even understand you. It's kind of blah, blah, blah.
I said, I'm sorry, and at first, my social security has been suspended since 2008, I believe it was. I'm trying to get that reinstated as we speak. I have an appointment for social security on December 2nd of 2025. I can keep Burnett County updated on the progress of my claim in regards to my social security. I wanted to see about getting the warrants quashed. And last but not least, I'd like to thank you for your time for putting me on your court calendar.
All right, thank you. Why are you in custody?
I'm on a probation hold, and then I also have court coming up on the 17th or 27th, I believe it is.
So you have new charges
Yes.
in
Tell you to report
Chippewa
to-
County?
Yes.
And so you're currently on $1,000 cash bond in Chippewa?
Correct.
Well, I will quash the warrant right now and I will stay your fines and fees until January 1st. But after that, if you don't start making your payments or we don't have a full hearing, I don't know what's going on with you, then the warrant will be reissued, okay?
Okay, thank you very much, Your Honor.
All right, thank you. I don't know where the Daniel person is, so, unless this is Burnett County Jail, the jail, do I have Daniel Blaowski? I don't know, so I'm sorry. It's just a bail modification hearing. He can have it another day. All right, let's go, Mr. Nornberg. Do you just need me to sign that warrant? Why don't you come on really quickly? I read it through and all good to go. Do you swear that the information contained in the search warrant and accompanying affidavit is true to the best of your information, knowledge, and belief? I do. There's no request to.
Judge Mogan, Judge Mogan signing a warrant there. Michael Groff here. This is the Courtroom Files Live. It's Monday. We've had a few technical hiccups. There's a lot of back end stuff that's involved, but we're going all right now. Let's get back to Judge.
With Ms. Van Kuren, can you please update the court?
Yes, thank you. I would like the opportunity to question Gregory Molly.
All right, Mr. Maley, please come forward, raise your right hand. You're going to be sworn in and come have a seat over here at the witness stand.
Do you affirm that the testimony you're about to provide in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, so just that other side of judge there.
Are you ill? Do you have a
Yes.
cold? Okay.
Yeah.
All right.
Chest
So,
cold.
Mr. Hanson, are you okay with Mr. Maley continuing to wear the mask?
That is fine.
All right.
So long as you can hear him, Your Honor.
I can hear, yep, and I can see him. You may begin.
Thank you. Can you state your name for the record again for me?
Gregory Allen Maley.
And Mr. Maley, there came a time, it was May 19th of 2009. On or about that time, you borrowed some money from Marsha and Richard Geisenhower?
Yes, I did.
That was about $30,000.
That was $15,000 at that time.
Okay. And then thereafter, they sent you $500 a month, right?
No,
Okay. What, if anything, do you recall about receiving money from Marcia or Richard Geisenhower in and after 2009?
in around 2018, 2019 timeframe, someplace in there, I borrowed another $11,000.
Okay. You don't recall anything about getting any money monthly?
No, there was no monthly statements. I mean, there's nothing there.
So
Just for sorry, Mr. Hanson, just for clarifications, you just said no monthly statements.
I mean, sorry, no monthly payments that they made to me. There were two lump sum payments that was,
Can you speak a little closer into the microphone? I just want to make sure that everybody can hear you.
okay. There was two lump sum payments that were over about a 2-year time frame from 2009 to 2011 and from 2018 to 2019.
okay. So there were two lump sum payments of $15,000 in 2009 and 2011. That's the first tranche.
Yep.
Okay.
Yep.
And then a second tranche later, about a decade later. What was the amount paid then?
Approximately $11,000.
Okay. Did you ever make any payments back? Did you ever return any payments to Marcia? Aside from signing the quitclaim deed, did you actually pay her back in cash?
No.
Did you, before today, did you look at your bank records to refresh your recollection as to these or any other amounts that you received from Marcia or Richard Geisenhower?
I don't recall any bank records that we did. I mean, I used the money to pay up any of the payments that were coming at me and things like that. That was about it.
Well, how did they send you money? Was it by check?
I believe so. That's, I mean, or they put it in my account because they had access to my account.
So, Marcia or Richard signed a check and then deposited into your account, and then you used it for paying off some debts.
And I just have to say, Mr. Maley, please just wait until Mr. Hanson is done asking his question.
Okay.
We can't have two people speaking over each other, okay?
Okay, thank you.
We appreciate that it's difficult, but please do your best. Thank you, sir. Okay, so so you remember a $15,000 in 2009, a $15,000 in 2011, and then an $11,000 in 2019. Do you remember any other loans paid by Marcia or Richard to you at any point?
No.
And those amounts were paid by them to you via check. They would have gone into your bank account at least temporarily before you used the funds, right?
Right.
Okay. Do you have where do you bank, or where did you bank from 2009 to 2019?
I have to remember. Bremer Bank.
Do you still have an account there, sir?
No, I don't.
When did you close your account at Riverbank?
And for the record, Mr. Hanson, it's Bremer Bank. I thought you said River.
I did mishear it. Thank you. Thank you very much, Your Honor. Bremer.
Yeah. Let's see.
When did you close the account, sir?
2024, they closed it for me because of just I couldn't keep up with it. What was it? I can't remember exactly what it was.
Was it insufficient funds or? not being able to
Insufficient
pay.
funds, yeah. Yeah, it was insufficient funds.
Got it. Okay, so you don't recall at all any monthly payments, maybe an automatic $500 a
No.
month?
No, there was no automatic $500 a month.
And I think maybe I'm being confusing in how I'm asking phrasing the question. It would have been $500 a month that Marcia had automatically coming out of her account and then going into yours.
Nope.
Does that sound familiar at all?
Never got it. And
Did
she
you
had
bring
access
with
to my
you?
account.
I'm sorry, I didn't mean to interrupt you.
She had access to my account.
So that is, you understand the possibility that Marcia could have been putting money directly into your account without you having to go into the bank and deposit the check, right?
Never happened.
Okay. Do you understand that that was a possibility based on what you say was Marcia's access to your account?
It could be, but it never happened.
Do you have with you, sir, today any records from Bremer Bank?
No, I don't.
Did you bank anywhere else to your recollection from
Community Bank
2000?
of Siren.
Again, just wait until he's done.
Sorry.
Do you have any recollection of banking anywhere else from 2009 through 2024 other than Bremer Bank?
After 2024 was Community Bank of Siren, Wisconsin.
Okay. And that's your current bank, sir?
No, not anymore.
Okay.
The fees were a little bit too high.
Let me see. I asked this question, maybe you answered it and maybe you didn't. If so, I apologize. Do you recall making any repayments at all to Marcia to the amounts that she?
No, I have not.
Again, Mr. Maley, just kind of wait until he's done. And I know that you want to be very responsive, but it's very hard for my court reporter to take everything down.
Sorry.
Okay?
Okay.
You understand your position in this case is stated by your attorney that you have a good faith belief that the debt is at least what it says here is $26,000, right?
Yes. That's what Marcia. That's what Marcia had written down.
Did you have any? Did you have any promissory note or other writings other than the checks themselves that would memorialize the amounts due?
No.
Okay. Do you have any recollection, or do you have any recollection of any agreement on interest or any other terms of the loan?
Nope.
Are you aware of the common law interest rate in Wisconsin of 5%? Does that sound familiar to you at all?
No, I don't recall.
Okay. So if you borrowed 15 plus 15 plus $11,000 from Marcia, so $41,000, why is it that you're claiming now that it's only $26,000 due?
Because that's what I owed.
But if you borrowed $41,000 and you didn't make any payments, how is it that less is owed now? Do you know?
I'm confused because I'm not hearing that any less is owed. I'm seeing the stipulation to be 26,000. I'm hearing from his testimony that one was borrowed, 15,000 was borrowed in 2009 and another 11,000 was borrowed in 2018. To me, 15 and 11 makes 26.
There's 15,000 in 2009, 15,000 in 2011, and $11,000.
No, that's not correct. That's not what he testified to.
Okay,
He testified in 2009, there was one $15,000 that was borrowed. In 2018 or 19, there was 11,000 borrowed. There was no other $15,000 that was testified to. I take extremely good notes and I have them here and I have a court reporter.
I also believe that you can hear the witness better than I can, Your Honor.
Yeah, do you need me? I can try and turn it up more.
I think we're doing our best in the circumstances, Your Honor. So
And
thank
he-
you for the
I'm sorry,
recitation
Mr.
of what the
Hanson.
testimony was.
He is mumbling, I think, because he is sick and because he's in a mask. And so that may be hard. And so, Mr. Maley, I really have to have you speak very, very closely to the microphone. Mr. Hanson needs to be able to hear all of the testimony because otherwise he's getting inaccurate or thinking he's getting inaccurate information.
Okay, thank you, Your Honor.
Okay. So I'm going to go over that again to make sure that I'm right. I'm sure that we all want to be accurate here. So the date of the quitclaim deed, that's you can look at it, was in your submission, May 19th of 2009. Did you do that at about the same time as when Marcia gave you the first, you say $15,000?
Yes.
And separate from that, there was an additional $11,000 that you say was loaned from Marcia to you sometime later. To the best of your recollection, when was that?
Approximately 2018 to 2019, someplace in there.
So if you admit that $26,000 was loaned to you somewhere between 7 and 16 years ago, why is it that you think that you only have to repay that face amount and no interest whatsoever?
Mr. Nordenberg, would you stipulate to interest? It would equate to about $2,050.
Yes, we'd stipulate to interest.
They stipulate to interest.
Okay. I have no further questions for the witness.
Mr. Nordenberg,
Mr. Maley, did you ever sign, I just want to confirm this, you never signed a note, like a note that showed how much you owed, no separate agreement in 2009 as far as what was being owed, what the terms were, what interest was, anything?
It was agreed upon. We didn't sign anything. It was just, word of mouth, I guess you'd say.
Okay, in the 15 years starting from then, did she ever try to collect anything or ask for payment?
No.
Did she give you a statement showing how much you owed?
No.
Okay. Not until August, correct?
Correct.
And that's when you signed the agreement?
Yes.
Okay, stipulating 26,000?
Yes.
All right, thank you.
I'm sorry, were there any further questions?
I'm sorry, there's no further questions, Your Honor.
further questions?
Okay.
All right. Okay. Do you have any redirect?
No.
You may step down. Thank you.
Thank you.
All right. Any other witnesses, Mr. Hanson?
Not that I can procure at this time, no.
All right.
Mike.
Go ahead.
My request again is based on this witness as well as my client's submission that records would be a lot more accurate and provide the information to a much greater degree of certainty. So
And
I
Mr.
do
Hanson-
understand that it's your discretion, Your Honor. It's your courtroom, and a lot of things happened before I got here. But that is my record, and that's my request.
Thank you, Mr. Hanson, and I understand your argument. Each has the same ability and capability of getting those documents. So Ms. Van Kuren could have already had those documents to you, and you could have had them and you could have submitted them here today to show that $500 a month from 2009 or thereabouts went from Ms. Geisenheiner's account to Mr. Maley's account. She had equal, if not better, access to get those documents to provide them for you here today for this hearing. And so I don't think we even need to wait or have any additional time because obviously they weren't provided to you, but other documents were for your review here today. And that is the basis for your argument and your request for an adjournment. I do find that, well, there is a stipulation as to interest. If you have a different interest amount, I'd be happy to have that presented to Mr. Nornberg and Mr. Maley for today's purposes, but the court comes up with $2,050 if you do $15,000 at 2009. And then 26,000 from 2009 to present. But again, I just did that hurriedly with a calculator, so I'm not certain, and that's at 5%. So if you have a different amount that you would like to argue here today as to interest, you are very able to do so, and I can give you a moment.
Yeah, I will, Your Honor. I'm pretty quick at such things. I was in fact a math major before I went to law school. Go figure.
I usually say that we go to law school so we don't have to do math.
I hate people who say that. It drives me bonkers. And just so that everyone's has the same underlying basis, it's Wisconsin statute 138.04 has the unless otherwise agreed, it's 5%. So it's $5 upon $100 for 1 year. So that's the legal basis for it. And I'm going to quickly put in my amortization.
And I believe, Mr. Norberg, you would, even though they didn't agree upon any interest at the time, you would agree based upon the statute that interest would be applicable.
Yes, Your Honor.
And I didn't use an amortization calculator either. I just simply was using math and a calculator, numbers and a calculator.
And it's not compounding either. I've had to do that before.
It's Mathematics with Mogan right here on TCF Live. Thank you for joining me. We're in a little bit of overtime. I feel like I owe you guys a little bit of overtime after the technical issues, so we'll hang here a little bit and maybe we'll pop over to one more thing here before we call it a day. We'll see how this goes. Anyway, they're doing math right now, so
my figure is a lot different. 5% interest over it's 16, just under 16 and a half years. That almost doubles the amount, which is why
but
I was.
you're not, but you're doing the 5% at 15,000 from 2009 to 2018, correct? And then 11,000 added, so then 26 total.
Yeah, so just doing them separately. $15,000 at 5% interest for 16.45 years, which rounds down a little bit. just the interest is $12,337.50. And that's separate from the 11,000. The 11,000 is actually easier because I'm going to use the 2019 figure. Again, if we can't pin them down between 2018 and 2019, I'm going to give them the benefit of the doubt for the single year. And that is exactly 6 years. So for that, it is $3,300. That is, say, $11,000 times 5% times 6. So the interest
what's
is
the figure?
The interest is 3,300 for the 11,000. 12,337.5 is interest for the second one. And the total is $41,637.50. 41637.5. Simple 5% interest.
All right, here's what the court's gonna do. I did order that $26,000 of the surplus is to be awarded to Miss Geisenheiner. And we do know the statute as it relates to interest. What the court is going to do based upon the arguments today and knowing the interest, I'm going to allow both sides to provide a written argument as to the interest and what they believe the interest to be, because quite honestly, when I quick did it, I didn't even do a compound. I didn't go to amortization calculator or anything of that nature. And then I will allow the parties to submit what they believe is the appropriate interest for this money. And then I will get my decision as to the interest out within a week.
Your Honor, practically speaking, I will email my calculation to Mr. Norenberg, and then he can respond either accepting it or submitting something else, and then we'll first see if there's an agreement on it. If not, we'll both submit our sides.
All right. That sounds good to me, Mr. Norenberg. You can speak with your client and you can discuss this with Mr. Hansen. Let the court know either you stipulate or you present a brief argument.
Okay, thank you.
Well, actually, yeah, so
Written argument.
I will give both of you, I will give you until November 7th to provide any argument if that's what you wish to do. And then I will get my decision out after that. All right, anything further?
No, thank you very much for your accommodations this morning, Your Honor.
Thank you, Mr. Hansen. Thank you, Mr. Maley and Mr. Norenberg. We are adjourned.
So,
oh, thank you.
Just a quick commentary on
All
that.
right, Mr.
That seems like a very crazy case right there. 5% interest. I mean, to me, you shouldn't even be able to collect a debt from 2009 here in 2025. I don't know what Wisconsin law is, but to me, that seems kind of excessive. Why not just take it 26,000, 5%? My math says that's $1,300. Call it a day. But why make things simple, right? All right, I said I think I owe you guys just a little bit of overtime. And so we're going to do a little bit here, just a little bit, and we'll head out to more Judge McNally. Let's see what's going on there.
You're going to plead to impeding traffic, right? Responsible or not responsible to that?
Responsible.
Plea is accepted. 150, you're all set. Original charge dismissed. Good luck to you. Thank you. Is Brownstown out there?
There, oh, very good.
Asia, yeah. Am I doing an arraignment on this too? Yes, apparently. All right, good morning. People against Asia Kashmir, Temp 25B 726-170. Detective, your name?
Good morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth. So help you God.
I do, Your Honor.
Okay, you can go ahead.
Your Honor, on October 26th of 2025 at approximately 3:26 a.m., officers were dispatched at 21544 Kings Point Boulevard, apartment 205 in Brownstown Township regarding a female complaint reporting that she was just strangled by her child's father. Upon arrival, Officer Bilecki conducted the investigation. He spoke with Asia Kemp, who stated that she was strangled by a male in the residence, Raymond Johnson, prior to police arrival. Ms. Kemp had a small scratch on her neck, but no other injuries or evidence of strangulation. She claimed she could not breathe when she was strangled by Johnson. However, she indicated that she did not lose consciousness. She stated she did not wish to press charges. Officer Bilecki then spoke with Mr. Raymond Johnson, who showed Officer Bilecki a cell phone video of the incident that took place prior to police arrival. That video showed Ms. Kemp sitting in bed before quickly standing up and physically attacking Mr. Johnson. The video ends as soon as she makes contact with Mr. Johnson. Looking at the metadata of the video, Officer Bilecki was able to determine that it was taken on October 26th of 2025 at 3:21 a.m., only 4 minutes prior to the creation of the dispatch emergency call. Mr. Johnson described being punched by Ms. Kemp several times and had several small cuts on his upper chest. He denied strangling her during this incident and indicated he wanted to pursue charges. Ms. Kemp and Mr. Johnson have 2 children in common and reside together at the 21544 Kings Point Boulevard, apartment 205 address. According to both parties, they're also married, although they never got a marriage license. So they are still legally single. Ms. Kemp was subsequently placed under arrest for domestic violence. She has no priors for domestic violence or related arrests or convictions.
Based on your sworn testimony, and find the crime of domestic violence was committed, there's probable cause to believe the crime was committed by the defendant and authorized the issuance of the complaint and warrant. And I'll note that you signed the complaint, court is signing and dating the complaint and the warrant for the arrest of the defendant. Your appearance?
COP 82378 on behalf of Ms. Kemp.
Ma'am, your name, please?
Asia Kemp.
All right.
As to the agreement, she stands being away reading around. As to bond, it's through the officer said in terms of the children, they do share 2 minor children together. Ms. Kemp is breastfeeding one of those children. That child is 8 months old. The other child is 2 years old. Ms. Kemp is not employed. She's a stay-at-home mom. I do see in the criminal history, there's something out of Dearborn Heights, but Ms. Kemp indicated to me that she was already put on probation for that, and she just owes some money. So she has a hearing date in November for that. Other than that, I didn't see any other criminal history. I would be asking for a personal bond so that she can at least get back to her children, because she does have some.
Where's she gonna see her children then?
Well, the father, to my understanding, has the children now, or her mother, or the children's father's mother. So when she's released, she won't have to get the children from Mr. Johnson. She can get the children from either of the grandparents. And she does have somewhere to go.
I think I'm gonna set this up for tomorrow. What is your position on bond here, Detective? Anything?
Yeah, we leave it in the court's discretion. We would just ask that she not be permitted to return to 21544 Kings Point Boulevard, apartment 205 in Brownstown. We'd also ask for a no contact order with Mr. Johnson.
And as I stated, she does have another address in Westland, her mother's home that she can go to when released.
$1,000 personal bond. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. No contact with Raymond Johnson except to effectuate visitation with the minor child. No contact. No no contact with prosecution witnesses except through your lawyer. You're not to go back to 21554 Kings Point Boulevard in Brownstown. You'll be allowed one visit and one visit only to obtain your personal belongings accompanied by a police officer. You're not to possess firearms. You're not to possess dangerous weapons. I'm hoping that somebody can take her out there today or meet with her out there today and hopefully referee anything between her and Mr. Johnson. So that she can take the children if it's agreeable. I'm setting this for tomorrow for a pretrial tomorrow, just in case. I think we need to do that. Lisa, what do you have for me tomorrow?
October 28th at 9:30.
Okay, ma'am, that's the best I can do. So you'll have to come here tomorrow at 9:30 in the morning. And if you want a petition for a court-appointed lawyer, you'll have to fill one out. The detective will give you one and you fill that out and it'll be sent over. Okay, you're entitled to a lawyer at the first appearance free of charge, but after that, you have to be indigent. Okay? So that's the best I can do. I'd like to help you with your kids by the same token. I don't want you two having any contact right now. Are you okay?
She just wants to get back to her children, Judge.
Well, I know, but what can I do?
No, but she can now.
Yeah, she can now, but I'm hoping that you guys can help her work this out, officer. Ma'am, are you okay?
Oh, I feel like I'm about to throw up.
All right. Can you help? Can you set her up where she can go out there and see him today, get her things out and get the kids out, and, or at least work out some kind of.
Your Honor, I'll talk to the sergeant that's on duty today about doing that.
Doc, we'll see you tomorrow, ma'am. Good luck. Thank you.
And apparently all of the police stations in Michigan, you know, it sounds like they're all in a canyon. Jeez. We'll make sure that we can get her the help. We'll get her out there and so she can get her stuff. All right, well, let's keep it going with Judge McNally.
Lanos, Nellie Olson, Camargo Lanos. I hope I'm thinking that's correct. 25B149596. How you doing? Your name?
Yeah.
All right. How you doing? Good. Nice to see somebody smiling up here. Huh? You're gonna plead to you gotta give him this again, John. Yeah. Dakota, have a seat right behind you, please. Dakota Vendia Chirillo, 25B149665. He's gonna tell me over now.
Accident.
Your name? You're going to plead to impeding, right?
Yes, sir.
Responsible or not responsible? All right, I'm gonna accept the plea. 170 is your total. Slow down, okay?
Thank you, Your Honor.
You're welcome. Good luck. Andrew Scott Mondelli, 25W840261. Good morning. Your name?
Andrew Mondelli?
You're going to plead to impeding traffic, true?
Yes,
On that charge, responsible or not responsible?
Responsible.
I'll accept the plea. 150, you're all set. Cash your end of the hall. You're right. Good luck.
Thank you.
Gloria Michelle Johnson, 25W840056. Your name, ma'am?
Lord, Judge.
You're going to plead to impeding traffic, right?
Yes.
Responsible or not responsible to that? Please accept it. Speeds dismissed. 150. You're all set. Have a good day. Thank you. Popovsky, Gabriel Christine Popovsky. 25W83881888. Did you already meet with a lawyer?
Yes.
Mr. Haynes, your appearance?
Ms. Popovsky.
I'm gonna need Ms. Tessino in here. Your name, ma'am?
Gabrielle Popovsky.
The charge is failure to attend the court work program on October 11th. Also failure to submit the testing is ordered on October 14th. I arraigned her. She said she wanted a lawyer. I entered a not guilty plea. How is she going to proceed?
I wanted to wait and see what Ms. Pino got here. She did miss these things, but she had pretty good reasons for missing them. She had tried to email Ms. Tessino. So I wanted to see if Ms. Tessino wanted to still support the violation. If she does, she would.
I'll let you talk to Ms. Tessino. How's that? Okay, thanks.
A little bit of overtime here.
Ma'am, Ms. Lanos.
TCF Live.
Recalling,
We'll hang for at least through the bottom of the hour or so, and we're with Judge McNally.
How you doing? Your name again? He's saying no two vehicle crash, no injuries, minor damage. You're going to plead to impeding, right? responsible or not responsible to that? Please accept it. Original charge dismissed, 195. You're all set? Yeah, how much time do you need? Do you work right now?
I'm a full-time college student and
Where do you go to school?
Wednesday.
Good. I'll tell you what, we'll just do, how about 30 per week? And I'll start this beginning November 20th, good? And if you need more time, if you don't have the money, things happen in life, just call the court. We'll go on Zoom or walk in here on it before your due date at 8:30, and I'll be happy to give you an extension, okay? Best of luck. Thanks. Thank you. Austin Edward Bain. 25T 646-476. Could I have Paul Emery seated at the table? Your name, sir?
Austin Edward Bain?
You're going to plead to impeding traffic, right?
Yes, sir.
Responsible or not responsible to that?
Responsible.
Please accept it.
Accept.
What's that?
Accept.
You accept?
My apologies.
You don't have to apologize. 160. You want this job? Come up here. I'll get. Good luck. 160. You're all set.
One request from you, Honor.
Yeah.
I'm currently employed.
When can you just tell me when you can pay it? December 5th?
That'll work out.
December 5th. Good luck.
Thank you.
Paul Robert Emery, you can stay right there, sir. 25W839749. You need time to pay? I'm sorry?
I'm going in ahead, so
Just tell me when you can pay. You don't need to.
I'm coming back on January.
Okay.
So, 8-week fold.
Good luck with your surgery, okay? Paid by January 15 of 26. If you don't have the money by then, just call the court on or before the due date. We'll go on Zoom at 8:30, or you can walk up here on January 15th or before then at 8:30, and I'll give you an extension, okay?
Thank you, sir.
Good luck with your surgery. Wish you well. Lisa Bunker. Lisa Suzanne Kelly Bunker, 25T 646-583. Your name, ma'am?
And Lisa Bunker.
All right, Ms. Bunker, you are going to plead to impeding traffic, true?
Yes, I am.
To that charge, responsible or not responsible?
Responsible.
All right, I'll accept the plea to dismiss the original charge. You're all set, 150. Thank you. All right, let's go. I thought he was ready. Minerva LeBron Rodriguez, 25T 646-683. Your name?
Minerva LeBron Rodriguez.
All right, so you know that then you're going to plead to impeding, right? Responsible or not responsible?
Yes.
Responsible? Please accept it. Speeds dismissed, 155. You're all set. How much time?
45 days.
Are you working? $30 due each week, beginning November the 20th, okay?
Can I make a payment, a first payment day and then start?
Yeah, you can then start on November 20th. Is that what you're saying? How much can you pay today?
40.
You pay 40 now and then 30 a week starting November 20. Good luck to you.
Thank you.
Tanner Richard Daniel. 25T 646-225. Good morning. Your name? You're going to plead to impeding, right?
Yes, sir.
Responsible or not responsible? Okay, I'll accept the plea. 160, cashier under the hall to your right. Good luck.
All right, thank you. sir.
Thank you. People against Popovsky. Gabriel Christine Popovsky, 25W8388-188. Your name? Counsel? Ma'am, your name? So what are we gonna do on this?
I'm gonna dismiss count one. She sent me an email, it didn't go through, and then she later sent it to me, so I will dismiss count one.
What's gonna happen to count two?
to plead guilty to count two, and then there's another one that I missed before that was added. The pending case, but it's not adjudicated. But she did pick up a no offense.
Not good.
Picking up.
She got 3 charges.
Technically two if I just missed count one.
I get it. So she was going to, so probation is going to move to dismiss count 1. And what is she going to do with the remaining 2 counts? She's going to plead as to count 2. What about the failure to refrain from violating a law?
Judge, the new offense is an automatic violation, but that case is still pending, so
Yeah.
I'm pleading guilty to violating. Don't quite there yet. She was pushing notes that she hasn't done the court yet. Or we can hold that one back and she can just stay to the count 2 at this point.
If you plead to get count 2, ma'am, that's a technical violation. You don't have any priors. You could get 5 days. If you're convicted on the other charge, that's a non-technical violation. You could get 93. Do you understand that? Did you sign, read, and understand the advice of rights?
Yeah.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yeah.
Is the count 2 that you failed to submit the monthly testing as ordered on October 14th? How do you plead? Failed to appear for testing on that day?
Yes, I want the next morning.
Anybody force you to plead guilty? I'm going to a not guilty plea. As to count 3, I'm dismissing count 1, motion to probation officer. I'm accepting the plea. Count 2. She's only been on probation for 3 months. This is not good. Can I see the screening report? I mean, you can always,
We only have her testing monthly right now, that's my concern. And then I was gonna see if maybe you wanted to consider changing her alcohol class to treatment. Just while we see how this pans out. I think there's probably more going on than we initially
of
realized.
course.
Judge, if I may, regarding the test from the 14th, she was on her way to the test. She brought a receipt of her passport on the way to the test. She tested the next day under the ETG and 5 seconds results were negative on both of those ones.
Does she have a court date on the other case yet?
It up like, I think Wednesday last week and nothing. They did send me the police report, but there's no court date when I looked it up yet. It occurred, yeah, 24th.
You should get the police report. I'm setting a sentencing date. Did we set the other one on November 3?
No.
What's the other date? You said November 13th?
13th and 17th, I'm on your violator day. I think that's the one.
Let's set this for November 13th. You acquire the police report. You should amend the charge.
I have the police report.
Good. You can add another charge, failure to refrain from consuming alcohol on that date. There's no reason I can't go forth with that. No reason I can't. PO to amend. We'll set all of that then, Lisa. Give me a time, if you would, please, on the 13th. And I'm going to go ahead, I'm sorry,
8:30.
at 8:30, okay, ma'am?
Do you want to keep her testing monthly?
No, I'm gonna do this, actually, as a condition of your bond, defendant to beat, and this is gonna be $1,000 personal bond. You're not only to comply with all terms and conditions of probation, you are to be on a SoberLink device by the end of the day and test weekly. Do you understand that? So we're going to have you do that. So that's a condition of your bond. So SoberLink by the end of the day, you're going to have to come up with some money and out to Livonia, right? Warrant. We're always changing. How much is it again? Yeah, that's what we'll do. And then you come back here for sentencing on that later date. Any questions? All right, good luck.
Thank you, Judge.
All right, ladies and gentlemen, with that, that'll about do it for day one of me sitting in for Mr. Dan Soul for TCF Live. And we started out great, wrapped it up pretty great, in the middle a little bumpy, little technical issues, but I was able to resolve those. And I want to thank all of you guys for all of your patience sitting here, putting up with all this nonsense of mine while we present you with, the best rendition we can of the TCF Live morning show here. So I really do appreciate it. Thank you so much to Lindsay, Barbara, Mama Joan, a.k.a. Grandma TCF, Bailey, Wahoo, all of you guys for your donations, your super stickers, super chats, and the gifted memberships from Barbara and Bailey this morning. All of that helps out. The super chats and super stickers help me. The gifted memberships helps the channel, helps Dan. You guys are amazing. And as Dan always says, and I have to agree, this is the best community in all of the LawTube space. No one even close to it. And now with over 27,000 subs on the channel, really, really do appreciate all of that too. Want to thank Michelle for all of her help as well from downstairs. And she is, of course, the executive producer over on my other channel, the Phoenix, Arizona Weather Discussion. And, of course, we do that weekdays as well. Just a little plug for that. Join us back here tomorrow. Now, tomorrow, I do have a note that remember the guy in Judge Simpson's court from the other day that blamed his incarceration on the Illuminati, everything from President Trump and Elon Musk all the way down to Judge Simpson's wife. Well, that gentleman is supposed to be back in Judge Simpson's court tomorrow morning. Now, Judge Simpson wasn't streaming today, so we didn't have the ability to bring you that. But that guy should be back in Judge Simpson's court tomorrow. So that could be a potential highlight. We'll try to keep an eye out on that. So we'll bring that to you if it is available. And so much more. That's a tease for tomorrow. We call that of the broadcast biz. All right. Otherwise, thank you guys so much again for the continued support, the well wishes, everything that you guys do. I really do appreciate it. We could not do this without you. And we'll be back here bright and early tomorrow, 10 a.m. East, 7 a.m. Pacific, 45 minutes early for channel members for the pre-show, which Dan will be hosting from somewhere on the road, presumably maybe in Texas. Yeehaw. So we'll see him tomorrow, and he'll have some updates from on the road as well. And we did some overtime today. I felt like I owed you guys that because of all the technical issues. So there you go. All right, we'll be back here tomorrow. Thank you, and be safe out there.